FR number ಮಾತ್ರ ಇಲ್ಲಿ ಬಾಕಿ ಆನ್ಲೈನ್. ಅಲ್ಲಲ್ಲ FR number ಕ್ಲಿಯರ್ ಆಗಿದ್ರೆ ಆನ್ಲೈನ್ ಮಾಡ್ಬೇಕು ನಾವು ತಗೊಂಡಂಗೆ.
Case number has been given, but matter has not been listed before the court.
You have to do online. Online ಮಾಡಿ. ಏನಾದ್ರು ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕಾಂಟ್ಯಾಕ್ಟ್. ಆಯ್ತಾಯ್ತು ಅದು ಬರುತ್ತೆ.
Assignments list 1, page number 1, 1 to 9, page number 2, serial number 10 to 20, page number 3, 21 to 23, page number 4, 24 to 30, page number 5, 31 to 38, page number 6, 39, page number 7, 40, 41, page number 8, 42 to 49.
My lord, serial number 42, my lord.
Yes.
Now we need to file fresh wakalat, my lord. This matter. Lord,
You appear for petitioner.
petitioners.
Have you informed the other side?
No, I'll inform you.
You inform and then report to the court officer. Because the other side was objecting previous occasion, saying some urgency. So that I don't know what the urgency is. They filed vacating interim order. You write a memo, you serve it on him, and then give it, or you inform telephonically and inform the court officer. I'll make a mark. Otherwise, when it reaches, I'll accommodate. Siddheshwar. 42 ನಿಮ್ದು ತಾನೇ ಅದು?
Lord.
So he's saying he's going to come on record. We'll have it on Monday. Office to show the name of learned counsel Sagar V. Shastri as representing the petitioner. We'll list the matter in same stage on Monday.
Page number 9, serial number 50 to 56.
I am for the in serial number 51. May I make one request, my lord?
Just wait, just wait.
Please.
Page number 9, serial number 50 to 56.
Yes.
51.
Yes.
Can I make the submission?
Yes.
I am for the petitioner. I have informed the learned government advocate also. ಇವತ್ತೊಂದು 2-3 parted matter ಎಲ್ಲ ನೋಡಿದೆ. ಹೀಗಾಗಿ the matter is fully covered by the judgment of this honorable court and there is some urgency. Could your lordship kindly have it on 12th in orders list? 15 ನಿಮಿಷ ಮೇಲೆ ಬೇಕಾಗ್ಲಿಕ್ಕಿಲ್ಲ. Matter is fully covered by the judgment of this honorable court that the land tribunal has directed that possession of the land should be taken over by me. The government has been directed to take possession from me. Matter is fully covered, and I am told that the LCR has been.
But before we next week is the last week. I really don't know if I'm going to have
12th. I will take a chance for that. 12th, kindly have it on 12th.
12th.
Matter is fully covered.
Let us release the matter on 12th.
And that name of the other council, Vishweshwaraya case may be deleted because I have entered Vakalat and filed Vakalatnama.
Office to delete the name of land council, Vishweshwaraya case. Yes.
The interim order may kindly be extended.
Interim order earlier grant is extended to the next.
Much obliged.
Page number 10, 57. Page number 11, 58.
Yesterday I moved this online. Mostly, not yet 3 weeks. It has done when I asked for a vacating of interim order, the matter posted 2 weeks. Lordship directed me to file a DA for vacating in which I have filed.
Correct. Next week we can't. Now we have to hear the matter in entirety. Until I finish the parted matters, I don't want to take up.
Only
Correct. I'll fix a date. You online only after 3 weeks that we have been asked to. Moor vara admil. Correct. It can't be moved within 3 weeks. That's the rule.
No, I will say. Can be the same.
Not next week. Not next week. Not next week. Until I have got 3-4 parted matters. I have not completed. I have to complete it. No, I have to finish that. So there's no point in having it listed. And you have online, after 3 weeks, you move the matter.
3 weeks after
That's why vacation next week in the issue. Next week in the issue. Not before vacation. No. Until I finish parted, I'm not touching any of them. Yes. Online move ಮಾಡಿ court officer ಹೇಳಿ 1:15. First online move ಮಾಡಿ. We can't accept according to
ready-made answer ಇದೆ online 3 weeks.
3 weeks ಅಂದ್ರೆ ಕಾಯಬೇಕು. That's some system they are trying to work out. Yes.
Lord, appeal to the one of them is really the other is not. Both the banks may be taken.
Mr. No, you're seeking for
Mandamus. There was an order passed by the commissioner directing the Tahsildar to reflect my name in the RTC entry. However,
no, but previous order is already a direction.
very clear. There is a direction.
Annexure?
Found it.
No, the order of the AC only they're seeking enforcement.
Not the order of the AC directs the Tahsildar to reflect my name in the RTC.
Correct. So you're seeking enforcement of that order.
Please.
That has not been appealed by the other side.
No, it has.
EGA accepts notice correspondence 1 to 4. List the matter along with WP number so and so in a preliminary hearing list on. They are seeking enforcement of the direction of the assistant commissioner, and that order has become final. So if that is so, it has to be implemented. Get instructions by them.
Not one more submission, Manoj.
Yes.
Now the council's name on the cause list is, in fact, my junior's name is being reflected. My name could be reflected.
Your colleague's name.
colleague.
Office to show the name of land council so and so, and as representing the petition. Yes.
Right.
But isn't this an appealable order?
No, the petition order is an amendment, annexure J, the improved order. Now, after Milord's more than 40 years, Milord's original order is amended. It's a.
Where is the original order?
The original order below annexure P.
Annexure?
Annexure, sorry, in fact, annexure C is the original order. Milord. The typed copy Milord is at page 40 start.
Yes.
This order Milord is passed Milord subject to survey because this is an enam land which is granted to the occupant, the respondent 7 and 8 years. But this order is sought to be amended. Annexure J can kindly be seen now.
First, you read this annexure, annexure C.
See, my name.
What is that?
Milord, typed copy at page 14. Arji ke samand, Lokamma and Ratnamma are the appellant. Respondent, Lord Swadevaya, Tikataya, Gopalaya,
Now
Padmanabhaya.
you claim.
Lord,
You claim.
I claim I am Padmanabhaya.
The respondent.
Four, respondent.
Yes.
Respondent number
So
4.
what happened in this order?
In this, Lords, what happened
You read
was
that
5
office.
acres of land,
Yes.
tenancy was conducted.
By virtue of this order.
This, but Lords, the survey was not conducted, and who is actually in possession? There is no survey from the land which ought to have taken subsequently. That did not take.
Correct. Now, after this order, Form 10 was issued or no?
Yes, my lords, it is issued. My humble submission is this. So, Lord, to make kindly seen now. Annexure J at page 96 may kindly be seen. This is sought to be amended.
No, just 1 minute. By any chance, you have enclosed the Form 10?
My lords, I have not informed.
Now, what is the order?
Now, my lords, by in this order, if lordship sees annexure C,
Yes.
by which survey number 60 Malur Nalli, 5 acre their Adibhogadari is confirmed.
Yes.
Now, my lord, lordship sees this order that is extended to 6 acre to 6.2 acre.
You are the landlord, is it?
Yes, I am the landlord. Subsequently, what happened, my lords,
No,
after
now, just 1 minute. At annexure J,
Yes.
what is the reasoning?
As per if lordship sees, the third paragraph at page 96,
Read.
Vadi evaraದ so and so ಅವರು ಜಂಟಿಯಾಗಿ ಪ್ರಕರಣ LRT ನಂಬರ್ so and so ಅಂತೆ ಮಾಡೂರು ಸರ್ವೆ ನಂಬರ್ 60ರಲ್ಲಿ 5 ಎಕರೆ ಮಂಜೂರಾಗಿದ್ದು ಹಾಲಿ RTC ಅಂತೆ ಸರ್ವೆ ನಂಬರ್ 60/2ರಲ್ಲಿ ಏನು TC ದೇವದಾಸ್ ಬಿನ್ so and so ರವರು ಹಾಲಿ ಅನ್ನುವಂತೆ 4 ಎಕರೆ 36 ಗುಂಟೆ ಮತ್ತು ಖರಾಬು 7 ಗುಂಟೆ ವಜಾತ್ ಯಥ 3 ಎಕರೆ 8 ಗುಂಟೆ ಕಡಿಮೆ ಅನುಭವ ಇರುವುದಾಗಿ ನಕ್ಷೆಯಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 60 ಈ ಹಿಂದೆ ಮೂಲ ಒಡೆಯರವರಿಂದ 2 ಎಕರೆ 35.8 ಗುಂಟೆ ಜಮೀನು ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುತ್ತಾರೆ. ಆ ನಂತರ ದಿಸ್ ಈಸ್ ಬೇಸ್ಡ್ ಆನ್ ಸಮ್ ಸರ್ವೆ.
What is 48A6?
Unofficial
Just 1 minute. Yeah. Both will be. I'm checking on this.
order of the witness under this section shall be final and the witness shall the copy thereof 48A6.
Only clerical or arithmetical mistakes.
Mistakes can be corrected. Here, my lords, an extent is changed based on a subsequent survey allegedly conducted. That is at annexure H. I have not been notified for that also. And this is not a mathematical error.
Petitioner. No, that is okay, but now that day, in that other matter, Pawan Chandra Shetty gave that order of the Supreme Court. It says beyond some years, you cannot amend the Form 7, the Supreme Court order dealing with the Karnataka land reform. So that we'll have to see. Secondly, now you can't you can't increase by 1 acre by way of order. That's a matter. But where you heard in this?
No, I have not been. I have not even made a party. Lordship kindly see 96, cast title.
Counsel to the petition. Submit that the owner of the is the landowner who had suffered an order before the land tribunal at annexure C, whereby an extent of 5 acres in survey number 60 of Malur village was subject matter of claim of occupancy rights, which was conferred on Lokama and Ratham. And the said order was passed on 11/9/81. He submitted that in the year 22, on the basis of an application for rectification, the extent of land has been changed from 5 to 6 acres. 6 acres to in exercise of power under 48 A6 of the Karnataka Land Reform Act. We submitted that the power under 48 A6 can be exercised only for arithmetic or clerical errors, which is not the case herein. A survey has been conducted behind the back of the petition, and the extent of land has been altered. In light of the contention raised, there will be stay of the order at annexure J. AGA accepts notice.
Alleged survey under annexure H.
1 to 4, 1 to 6. Emergent notice to 7 and 7 to 10. No stay of annexure J.
Yes.
And proceedings pursuant there. Which year order you are challenging? Which year the order is challenging? 81.
It is the order of the year, very old order.
No, so I would recommend before entering into the merits, you take a chance into the other after vacation.
My lord, my
81 order.
please, I will make submission on that. My lord.
Correct.
Of course, order is of the year 81. Wherein she claims that he has claimed 50 cents in that survey number 46/8. And before he has given the statement before the tribunal saying that I have not been in possession of these lands. I have claimed other lands also. And he categorically states that I am in possession of only these lands. Therefore, please reject my claim. Please kindly see I have produced a copy of the that document, that is the statement before the tribunal as per annexure E. Kindly see at page number 46 and typed a copy at page number 47. May I read, that is the typed copy, page number 47. Bajpe Gramada survey number 8/2, 346/8, 9/3 and early ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದರ ಮೇರೆಗೆ ಈ ದಿನ ಸರ್ವೆ ಅಳತೆ ಬಂದಾಗ ನಾನು ಹಾಜರಿದ್ದು ನನ್ನ ಅನುಭವದ ಗಡಿಯನ್ನು ತೋರಿಸಿ ಅಂತ ಅಳತೆ ಮಾಡಿರುತ್ತಾರೆ. ನನ್ನ ಅನುಭವ 8/2A, 2B, 3A, 3B, 8/4, 9/3A, 9/1 ಈ ನಂಬರ್ಗಳು ಮಾತ್ರ ಅನುಭವವಿರುತ್ತದೆ. Wherein 46/8 is not there. Then ಉಳಿಕೆ ನಂಬರ್ಗಳಿಗೆ ನನ್ನ ಅನುಭವ ಇರುವುದಿಲ್ಲ. ನಾನು ಮತ್ತು ದನಿಗಳಲ್ಲಿ ಒಬ್ಬರಾದ ಆನಂದ ಶೆಟ್ಟರು. Whereas here the landlady is Janaki Shetty. She got the land by virtue of the partition in the registered partition. Then may I take your lordship to the next document, that is the survey report. That is the next document, annexure F, page number 48 and sketch. Then the typed copy at page number 50. Wherein she categorically, that is in the surveyor 46/8, last item, my lord, in the column. Anubhava irudilla. Because she is not in possession. Still, the tribunal was pleased to grant 20 cents of land. This is the position. Even RTC was standing in the name of Janaki Shetty. No notice was issued. Even the tribunal order, if it is there, it shows that notice was issued to Ananda Shetty, not to my vendor, because I am the purchaser of the land. And RTC was standing in their name. In 2004, they filed the partition. LR of Janaki Shetty.
What I want to know,
Please,
that this one.
please, I will make submission.
What I want to know is that after this order of the tribunal, where RTC is changed.
No, in their name it was not at all changed. And in 2007, my lord, I have purchased the land. Immediately, mutation was affected because it is a dry land also, apart from that.
Mutation was affected.
In my name. And that mutation order was challenged in 2014 by the respondent. Then I came to that occupancy right was granted. Immediately, I am the purchaser, stepped into the shoes of the original owner, filed the writ petition before this honorable court in 2015. Then, when the matter was listed before this honorable court in 2023, that is in the April, then the court opined that it's better to challenge along with the original owners, because though I arrayed them as respondent 2 to 16 in that writ petition. I have produced the copy also. Therefore, I filed a memo. I sought for liberty from this honorable court, and this honorable court was pleased to grant liberty. Then I filed the present writ petition. Then, my lord, they have challenged it in 2014 mutation entry in my name. Immediately, I came to know that such order came to be passed. Therefore, there is a delay. There is nothing. Even there is no claim. She categorically, the person who filed, please. It has to order because I am in possession. It is a dry land, my lord. It is not a land as defined under the Land Reforms Act, section 218. It is beyond the scope, and the tribunal has no jurisdiction also to grant. When the person who claimed,
Let us see.
no owner, who is the owner? Anand Shetty is not the owner. I have produced the documents. He is not the owner. I am the owner. I have produced the earlier partition also.
This is argument.
Argument because
I've got your point.
Please. My lord, my humble request. I have been in possession of this entire 1 acre 6 cents. Let the status quo order may be passed.
Let us. EJ accepts notice for respondent 1 and 2. Emergent notice to the third respondent. Petitioners, you want to take out notice by way of hand summons? I'll permit you.
This one, my lord, I will not hand summons.
Emergent notice to
Process of the court. Emergent notice.
consideration of interim place kept open. This is the matter in the week commencing from 30th. Notice was not served.
That is one of the reasons. And then, my lord, the conversion has taken place in 2006. The proceedings initiated in 2008. And proceedings initiated against my predecessor in title. My vendor proceeding 2005. This Kogineni has sold the property in 2006 to my vendor. And proceedings initiated in 2008.
But now what we have been doing is, can he not join?
I understand. I've seen your lordship.
Can he not join? This respondent before the Assistant Commissioner. Can he not join in this petition?
We can go there, my lord. We can, if it is demanded. He may not, my lords, because he sold the property in 2006 itself. I don't know whether he will come and participate in the proceedings.
We have stated, but not as a position of law. But generally, person he has to also join, is what we have said. If he cannot, then
because
But there is a specific direction that the applicant has initiate proceedings by giving notice to the present petitioners and clear the matter of the ordinance.
Just read the order.
And, page 21, my lords.
Yes.
Second paragraph. Okay.
First page. Page 20.
20, yes. The first paragraph only.
Yes.
Last 3 lines.
Yes.
ಈಚೆಗೆ ಜಮೀನು ಪಡೆಯಲು ಪ್ರತಿವಾದಿಗಳ ಅರ್ಹರಾಗಿದ್ದರು ಅಥವಾ ಇಲ್ಲವೋ ಹಾಗೂ ಇವರ ವಾರ್ಷಿಕ ವರಮಾನ ಬಗ್ಗೆ ತಿಳಿಯಲು ಪ್ರತಿವಾದಿಗೆ ಅಂತಿಮವಾಗಿ ದಾಖಲೆಗಳನ್ನು ಹಾಕಿಸಿ ನೋಟಿಸ್ ನೀಡಲಾಗಿದೆ. ಪ್ರತಿವಾದಿಯವರಿಗೆ ಕಯಾಪದಲ್ಲಿ ಕಂಡ ವಿಳಾಸಕ್ಕೆ ನೋಟಿಸ್ ನೋಂದಾಯಿತ ಅಂಚೆ ಮೂಲಕ ಹಾಗೂ ತಹಸೀಲ್ದಾರ್ ಮೂಲಕ ನೋಟಿಸ್ ಕಳಿಸಲಾಗಿದೆ. ಜಮೀನಿನ ಮೇಲೆ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದೆ. ಪ್ರತಿವಾದಿಯ ವಿಚಾರಣೆ ದಿನಾಂಕದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಪ್ರತಿವಾದಿಗಳು ಪರ ವಕೀಲರ ಹಾಜರಾಗಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಹಾಗೂ ಪ್ರತಿವಾದಿಯು 1/74 ವ್ಯವಸಾಯಗಾರನ ಸಮರ್ಥಿಸಲು ಯಾವುದೇ ದಾಖಲೆಗಳ ಹಾಜರುಪಡಿಸುತ್ತಿಲ್ಲ. ಹಾಗೂ ಪ್ರತಿವಾದಿ ವಾರ್ಷಿಕ ವರಮಾನ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತಿಲ್ಲ. ಸದರಿ ಕ್ರಯದ ದಸ್ತಾವೇಜು ರೂಪಾಯಿ 12,60,000 ರೂಪಾಯಿ ಕ್ರಯವಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಅದರಿಂದ ಕರ್ನಾಟಕ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 79A ಮತ್ತು B ಸ್ಪಷ್ಟ ಉಲ್ಲಂಘನೆಯಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಇವರು ಒಟ್ಟು ವಿಭಾಗದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಇದರಿಂದಾಗಿ ಪ್ರತಿವಾದಿಯವರು ಕ್ರಯಕ್ಕೆ ಪಡೆಯುವ ಸಂದರ್ಭದಲ್ಲಿ 2 ಲಕ್ಷ ರೂಪಾಯಿ ಮೀರಬಹುದೆಂದು ಪರಿಗಣಿಸಲಾಗಿದ್ದು.
But why that? When did you purchase?
My vendor purchased it in 2006.
Yes. Yeah. The respondent before the assistant commissioner is your vendor.
My vendor's vendor.
Now he sold it to your vendor on
In 2006, my lord. 18/8/2006.
What is the name of your vendor?
G. Shankar.
2006.
Please.
And then you purchased on?
Between 2007 to 2016, the petitioners, my lords, purchased. Before that, my lords, on 16/11/2006, conversion takes place.
You purchased on?
Between 2007 and 2016, the petitioners have purchased because layout was formed, and the petitioners purchased between 2007 and 2016. Only one survey number, my lords, that is survey number 400, 2 acres, 3 guntas is involved.
Notice was served.
Notice was served on my vendor's vendor. He appeared, but he did not produce any documents for the order records. By then, my lords,
Correct. When did you come to know about this?
December, my lords, 2022, they went to avail loan. At that time, they came to know that these proceedings are initiated and mutation, the state's name is reflected. And then we had to gather the number of site owners pertaining to 400 bar survey number 400. That took some time, my lords.
The petitioners. Is it a case for costs? Is it a case for cost or no?
If they have appeared and if they have produced this conversion order, I think then the proceedings are
You pay some nominal costs. For Devanalli, nominal is okay. The petitioner. Because in all matters where there is delay, we are imposing some costs. The petitioners have challenged the order of the assistant commissioner at annexure A, whereby the predecessor in title of the petitioners has suffered an order. The assistant commissioner has declared that the sale deed dated 18/8/2005 relating to an extent of 2 acres 3 guntas in survey number 400 of Devanahalli, Espa Hubli, Devanahalli Taluk to be in violation of 79A and 79B of the Karnataka Land Reforms Act, and had further declared that the property would stand vested free from encumbrances with the government. And counsel for the petition submits that the order is passed against the petitioner's vendor's vendor. He submitted that Bogineni Kamalendra Kumar, who is the respondent before the Assistant Commissioner, had sold the land to one G. Shankar on 18/8/2006, earlier to the initiation of proceedings before the Assistant Commissioner, and thereafter petitioners have purchased through sale deeds executed in the year 2007 to 2016 by Sri G. Shankar. Next, it submitted that the respondent before the Assistant Commissioner, having sold the property, though appeared before the authority, has not evinced any interest in prosecuting the proceedings diligently, which has resulted in an adverse order being passed and affecting the interests of the petitioners herein, in whose favor the sale deeds were executed. Further submitted that even prior to the initiation of proceedings, land has been converted on 16/11/2006, which would indicate that power has been exercised without taking note of relevant facts. Next, it's also submitted that in light of omission of 79A and 79B, another opportunity may be granted by relegating the petitioners before the Assistant Commissioner after setting aside the impugned order. Produce the impugned order and notice the contentions of the petitioners regarding execution of sale deeds prior to initiation of proceedings at Annexure A, which cannot be stated that the petitioners will not be affected by the outcome of proceedings before the Assistant Commissioner. Noticing that the respondent before the Assistant Commissioner, though filed wakalat, has not participated in the proceeding, and in light of omission of 79A and 79B from the statute, it would serve the interest of justice by affording an opportunity to the petitioners herein also to participate in the proceedings along with the respondent before the Assistant Commissioner by relegating the matter for fresh consideration. Accordingly, the order at Annexure A is set aside. The petitioners to appear before the Assistant Commissioner without notice on 6th November. Petitioners to file applications to implead themselves in the proceeding before the Assistant Commissioner, and if such application is filed, they may be considered so that the petitioners may also be granted an opportunity of hearing. Needless to state, notice will have to be issued to the original respondent before the Assistant Commissioner, as is revealed from the cross title of the order at Annexure A. While reconsidering the matter, the Assistant Commissioner also to consider legal effect of omission of 79A and 79B from the statute book. Next, taking note of the delay in challenging the order, though the counsel for the petitioner submits that they were not aware of the order. However, the petitioners to pay costs of 10,000 to the High Court Legal Services Committee within a period of 2 weeks. AG accepts notice.
If property is being petitioner.
Government advocate for
Yes,
similar and the same petition.
property.
Same property. Now, what is the order passed?
There is a delay of 43 years.
No, what have you challenged? ಫೈಲ್ ಇಲ್ಲಿ ಫೈಲ್ ಇಲ್ದೆ ಹೆಂಗ್ ಬರ್ತೀರಾ? ಅದು ಯೂನಿಫಾರ್ಮ್ ಇಲ್ದೆ ಕೋರ್ಟ್ ಬಂದಂಗ ಆಗುತ್ತೆ. ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಯು ಗೆಟ್ ದ ಫೈಲ್. ನಾನು ಏನಾದ್ರು ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ಗೆಟ್ ಇಟ್ ಪಾಸ್ ಓವರ್. ಎಸ್.
Fixation of the time to disposal of the RA proceedings which being pending before the Assistant Commissioner of Bedapur Lordship. Last date, direction given to the state to confirm the time frame, Lordship.
Just find out. You find out. He's only seeking for disposal of RA.
Although it was remanded by this honorable court itself, Lordship, in the year of 2019.
Let us see.
Yes, please, Lordship.
There are many people who are waiting like you. We find out Monday. We'll list the matter on Monday. In the same stage.
One more request, Lordship. Along with Ravi Shankar, Praveen Kumar NK name may be showed in the cause list.
Show the name. Learned council, so and so.
Yes, Lordship, we'll write it.
The present council shown as representing the petition.
Thank you, Lord. What else?
Yes. Whereas you place your stand, let them also know. Then you take your stand, you file your. Because now, so even if we were to dispose it out, it will come back to the same stage. If they are taking a stand, let them take it in this.
There is possession of whatever the name of system, there is possession of that land. Not till date. Apparently there is possession.
So then you take your stand in writing, that is.
We are seeking for another, seeking another insurance for Kotamala.
So then you take your stand in writing, let them know the AGA to file statement within 2 weeks. This is the matter in week commencing from 6th. Why was it adjourned?
ಅವರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳಿದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ತಾರೆ ಅಂತ
ಇದರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದ ಮಂಜುನಾಥ್ Then shall we pass over? So we can get that and let him also have a look at it. Correct. Yesterday's matter. Yesterday's matter. Before the Assistant Commission. Beyond the ceiling limit. Beyond the ceiling limit. Manjunath Prasad's matter. Shivram Bhatt. Correct. You have a look at it. Have a look at it. Now the rules are amended. So the rules say that you have to follow that procedure.
One submission. Land grant order pass this annexure A, my lord. Order adರಲ್ಲಿ ಒಂದು condition is annexure A page 12.
No, correct. Now this is a temporary lease,
Temporary.
Annexure A.
ಅದಲ್ಲ annexure A ಅಲ್ಲಿ permanent grant ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ DC ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ page 10 type record.
Regarding the rate, is it? Rate.
Market value no?
Correct. Now that is applicable retrospectively. We'll list the matter on Monday. Have a look at that. Now, according to that rule, which we are following in other cases, we'll have to pay market value. But Assistant Commissioner will have to dispose of within 3 months. Have a look at it. So still price is not finalized. Price. Now you can find out if you are willing to pay the government value in terms of the new rule. Then Monday we can dispose it. Have a look at that and look at it. So the only contention is now we can't go back. The price will have to be fixed in terms of the new set. Monday. Yes, what is this matter?
This serial number 9, my lord. I appear for the petitioner in 9.
Yes.
This pertains to Raj Kaluwe.
Just one. Yes, just one. Yes.
not go.
Seven two. Correct. Huh? Now the only point is when we send it back, it should not come back. $67.2. Now both the cases.
Yes.
Particular strip of land, which myself and my friends, we have relinquished this land to the BBMP. Now, in fact, it is in this land that the markings have been done. Though the sketch would say, my lord, the annexure K, which is annexure K in my written petition. This is the alleged sketch which they.
Annexure?
K in my written petition.
143. Yes.
Lord, what is interesting is, my lord, my survey number is 19/3, myself and my friends. But the alleged encroachment in annexure K indicates the encroachment is in 19/1. The markings, they come and do the markings on the compound wall on the road which is relinquished. Now we have relinquished this road to the BBMC. So my lord, all I'm saying is when they do the survey or issue the fresh notice, let them take into consideration all these aspects. Let them consider all these aspects and redo the matter. They are doing it 67. Let them redo it in a comprehensive manner is what I'm trying to say.
Have this survey is prepared by?
It is prepared by
Was it done in your presence?
No, nothing was done in my presence. No, not done in my presence. This I downloaded it from their system because along with the notice they said sketches appended. No sketch was appended. I downloaded it and I found it and then I produced it for my lodges.
Now we can say while sending it back and they initiating proceedings under 67. The basis for that inquiry and alleged encroachment should be on the basis of a sketch prepared in their presence. And BBM.
The notice was issued to BBMP because the property now the area falls within their limits.
So both can be disposed of by a common order.
Please, Madam.
Yes. You have to serve a copy on the council for BBMP.
Please, Madam.
WP 94 doesn't come into play.
It does not come to play.
Then 94. The petitioners in WP 18157 of 23. Petitioner is the Krishna Royal Apartment Owners Association and have challenged the notice at Annexure A issued by the Tahsildar dated 31/10/2022. Issued under Section 104 of the Karnataka Land Revenue Act. By virtue of the said notice, it is submitted that by virtue of the sketch prepared by the surveyor, taluk surveyor, it appears that there is a encroachment of government land in survey number 19/1 of Munne Kolalu village, Vattur Hobli. Notice states that there is an encroachment of the Kalwe within inverted commas. In WP number 2664 of 2023. Now this is filed by?
This is filed by the present landowners. One rare portion what we had sold to the developers who are now apartment owners.
So you are the landowners.
We are the landowners.
By the landowners.
Of the portions that we have still retained.
With respect to the portion retained by the landowners in survey number 19/3 of Munne Kolalu village, Vattur Hobli, Bangalore East Taluk, whereby they have challenged the notice at Annexure A issued by the Tahsildar under Section 104 dated 31/10/22, whereby the notice makes out a case of encroachment of the Kalwe land in inverted commas. As the subject matter of dispute relates to land adjacent lands and the assertion made in the notices are identical, both the petitions are taken up together and disposed of by a common order. Third, AGA fairly submits that the Tahsildar has no jurisdiction to issue notices under 104 in the present case as it relates to alleged encroachment of the Kalwe system. It is further submitted that insofar as encroachment of Kalwe is concerned, the appropriate inquiry to be made is under Section 67(2) of the Karnataka Land Revenue Act. Third, counsel for the petitioners would further, in both the matters, would further draw attention to the survey sketch at Annexure K in WP 2664 of 23 and submit that the notice of the Tahsildar is based on the sketch prepared, which demarcates the encroachment, but however, such sketch has been prepared in the absence of the petitioners, and accordingly, even if proceedings are initiated by the respondent authorities afresh, if they base it on the sketch at Annexure K in WP 2664 of 23, it would result in injustice caused to them. So accordingly, it is prayed that the survey be prepared afresh in the presence of the petitioners in both the writ petitions and on the basis of the sketch prepared in such survey after notice to petitioners in both the matters and other affected petitioners in both the matters, the proceedings as per law may be permitted to be proceeded with. Next, after hearing both sides in the matter, in light of the stand of AGA, the notices at annexure A are set aside. Next, however, insofar as the further action to be taken, it is ordered as follows. A. Survey be conducted in the presence of the petitioners in both the matters, wherein the sketch to be prepared demarcating encroachment, if any. B. Subsequently, once the survey process is completed, the Deputy Commissioner to take note of to take proceedings. It is open for the Deputy Commissioner to take proceedings in terms of Section 67, Clause 2 of the Karnataka Land Revenue Act and follow the procedure therein. Needless to state, upon conclusion of such inquiry, petitioners are at liberty to seek redressal if they are aggrieved in terms of 67.
Can I make one
67.
more?
Yes.
To identify the causeway, whether it is within this survey number 19/1 or 19/3, because as per their own admission, they say it is in 19/3, but they come and make the markings in my property. So they have to first identify whether the causeway is in 19/3 or in 19/1 or in 19/2.
But that now the survey will be done in your presence.
In my presence, but let them identify where is the causeway running, my lord. Are the consultant to identify where?
We list one clause. The identification of the causeway is to be done on the basis of the records maintained by the ADL. Copies of all documents to be shared with the petition.
Much of.
And Council Shri N.R. Jagdishwar has permitted to file wakalat in both the matters. The BBMP also to be notified at the time of survey.
Implementation of RTC, number 87 of Singapore, and as it was the 17th or as per the Krapta and the Akhara, they given the representation that has not been considered. Thinking worship for that. That's right. Because based on the what the happened is, see now this petitioner have represented, given representation they are not considered, and the subject of the land has been entered into the agreement of sale.
Just 1 minute, just 1 minute. I also have to prepare some Javanese sketch. Consider the petitioners have sought for issuance of writ of Mandamus to direct the respondents to consider representation dated 26/4/22 made by the husband of the first petitioner and father of the second petitioner in respect of land bearing new survey number 87, old number 17/2, situated at Veerapur village, Kudur Hobli, Magdi Taluk, Ramnagara district. Full stop. The petitioners made a detailed representation at Annexure A, which is self-explanatory. Upon instructions, the CGP submits that the same would be considered as per law. In light of the said submission, the representation at Annexure A to be disposed of in accordance with law in a period of 12 weeks from date of issue of certified copy of the order. If the subject matter of request is to be considered in the affirmative, the authorities to take action expeditiously to consider the request and take appropriate action. Needless to state, petitioners to assist the authorities by furnishing information and documents as may be necessary for consideration of the request. Accordingly, petition is disposed.
I made a respondent number 3 and 4 in the formal party. My vendor in British title has purchased property in 1982. 1995, 79 AB proceedings were initiated in 1995 and 96. Sale deed Milord is pertaining to 31/8/1982. After lapse of 13 years, initiated the proceedings by 31/8/1982. After lapse of 12 years, proceedings initiated. As on the date of initiation of proceedings, already my vendor sold the property in 1992 to one Gangappa and another Milord. That also they are also not made as a parties. But this part of order Milord has been challenged by one of the total 6 acres 8 meters of land in survey number 15. But 4 acres and 8 meters is concerned, they filed an appeal. One of the party purchaser who purchased the property that was set aside by the Karnataka Appellate Tribunal in long back in 1997 itself. Insofar as 2 acres is concerned, the notice was served to the vendor, that is respondent number 3 and 4 before the land tribunal, the assistant commissioner. Therefore, the impugned order was served on the land, notice was served on the land, and the impugned order was passed. But we are the purchasers. In 2001 to 2014, the order was passed in 1995.
Yes, now the original sale deed is
31/8/1982, my lord.
Executed in favor of?
Executed in favor of respondent number 3 and 4, my lord. It is forthcoming from page number 55. May kindly look at, my lord, AAT order. Page 55 may kindly look at, Milord. The order passed by the Karnataka Appellate Tribunal. There is a finding, Milord, may kindly. Page 55, para number 8, Milord. May I read, Milord? It can be made out from the lower court records that respondent 3 and 4 purchased only 2 acres in land in survey number 15 of from Kalyanappa under the register sale deed dated 31/8/1982 for a sum of 12,000. But the impugned order was regarding to the entire land of 6 acres 8 meters. Prima facie it is illegal. And further, Milord, the KT itself, Milord, has passed further paragraph. Can you look at, Milord? Now it is the case of the appellate that the entire land 6 acres 8 meters was given who are under the register sale deed in 1955 in the list. The lay of the Meher from her husband.
Now, 31/8/1982, responding 3 and 4 have purchased this land. Now they have purchased 2 acres.
2 acres. They sold 1992.
Just one, they have, and then they sold it in
1992, my lord.
in favor of
One Gangappa and Ranganna on 17/10/1992. The proceedings initiated in 1995, my lord. In that order was challenged by another portion of the landowner before the KAT. KAT was set aside the order because non-service of notice, my vendors were not in a position to challenge, and the order was only in so far as 4 acres remaining portion. KAT.
You said 2 acres.
2 acres is my vendor, my lord. The remaining extent out of 6 acres 8 quintals, 4 acre 8 quintals 6 acres. It was set aside already, my lord.
Present dispute is with respect to 2 acres.
2 acres, lord.
The 2 acres
Yes,
was sold to R3, was executed by R3 and 4 in favor of Gangappa and
Rangappa in 1992, 17/10/1992.
from them you have purchased.
He sold again, my lord, in form of the layout and sold in 2001. We are the 2001 to subsequent sale list.
You have purchased.
We are all the purchasers, petitioners. We are the sites purchased, various sites.
Proceedings are initiated in
1995, my lord. After lapse of 12 years. Lord, my submission, my lord, is that while passing the KAT order, my lord, already held that it is an entire 6 acres is also an illegal finding is there, but order only in so far as 4 acre 8
where
because
is that finding?
that finding may kindly look at page number, now I read you page number 55. Prima facie it is illegal. Now, my lord, in the next paragraph, my lord, is kindly look at the last 4 lines. Thus, we are the opinion that the impugned order forfeiting the entire 6 acres of land is an illegal. There was no transaction at all regarding 4 acre 8 acres of land belonging to the present appellant. Unnecessarily, they have dragged to the court.
That is with respect to 4 acres because there was no transaction.
No transaction, but 6 acres is also an illegal finding is there.
Not on merits.
Lord, my submission.
No, however,
notice was not. Notice was served to not served to my vendor in 1995 because notice served on land, it is mentioned in the impugned order, page number 46.
But what do you say regarding exercise of power?
After 12 years, my lord.
Why the delay?
The delay is, my lord, is concerned. The purchasers, my lord, in respect of property in 2004, 13 and 15, RTC only find out, my lord, they came to know this because while applying for mortgaging for construction of building, they went to the bank loan. Therefore, my lord, they find out that it is a Sarkari Jameen. Then, my lord, they ascertained and enquired the copies and collected documents. Because we are not a parties, we are nowhere concerned. This is a layout and we are the purchasers from 3 to 4 transactions taken place from 1982 to 1995. It is not within the knowledge of the petitioners because they are not a parties to any of the orders. And moreover, they were not my vendors predecessors in title only parties to the impugned order.
Even the respondents were not parties. Were not served, sorry. But they were not served.
Notice was served
ಜಾರಿ ಮಾಡಿ.
On the land.
Para page 46, Milad, para number, last para number.
We have kept quiet for how many? 30 years.
We are the purchasers, Milad. All the subsequent sale dates. We are not, the impugned order, Milad, prima facie, Milad, 17 proceedings now, Milad, has been, as government has been taken.
But don't go to that.
Only this extent, Milad. My submission, no notice was not served. It is not within the knowledge because they served on the land. They have not ascertained, and anyhow portion of the order also, Milad.
To pay cost.
Some reasonable, Milad.
It's reasonable. This order, why you didn't challenge before the KT? Earlier.
Now, Milad, we came to know recently, therefore we are not challenged. Now KT is for Milad to take a proceeding 17 proceedings. In view of the subsequent.
When was the records changed in the name of the government?
Government records RTC, Milad, I have placed. All parties named, Milad, in page number 556, MR 566. Page 556, 566. Mainly see that mutation extract 2013 and 14, where KT order ante badla. Please kindly find out that MR H9/2013-14. In the last, Milad, top of the order, Milad, may kindly look at Milad. KT appeal 2276 of 97 ದಿನಾಂಕ 12/6/1998 ಆಧಾರದಂತೆ ಈ ಹೆಸರುಗಳನ್ನು ತೆಗಿತಾರೆ, ಇದರನ್ನು ಬದಲಾಯಿಸ್ತಾರೆ. ಲಾಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟುಗೋಲು MR number 17/96 ಒರಿಜಿನಲ್ ಬದಲಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟುಗೋಲು 2 acres only, ರಿಮೈನಿಂಗ್ 4 acres ಚೇಂಜ್ ಮಾಡ್ತಾರೆ.
2 acre.
Yes, Milad.
Has been
MR
changed in 96.
90, MR 17/96-97.
Correct. Then why you didn't find out?
Milad, we are not the purchasers, Milad, on the
Mutation is changed.
mutation change, Milad. 97-92, my vendor is a owner of the property. His name also not reflected in the KT order. He doesn't know about that. He is not a party at all. 1992 purchaser is not a party at all. While changing 97, 92 purchaser is not made as a party in the impugned order.
Not necessary. Sale deed is only of that person.
Milad, even to that extent also, Milad, 95, admittedly 92 sale deed owner is the Khatedar. They are not made as a party.
Petitioners. I have called in question. How many petitioners are there?
Milad, 50.
They pay costs of 2,000 rupees each petition. Petitioners.
53 petitioners.
Yes, our group. On site. Legal services gather contribution. Because this is a borderline case. We kept quiet since 96. The petitioners. Sought for issuance of writ of certiorari to set aside the order dated 28/2/1997, passed by the second respondent, Assistant Commissioner, whereby the Assistant Commissioner has declared that the sale deed dated sale deed dated 22/91.
Yes, 22/1997 and it is referred. But their sale deed is 1982. Milad. In the impugned KT order, it is referred. Page 55.
Correct. In annexure A, what is the sale deed?
Sale deed date not mentioned, Milad.
Whereby the sale deed of respondent 3 and 4 herein, who were respondents before the Assistant Commissioner, were declared to be in violation of 79A and B. And land was directed to be vested with the government. Land Council for the petitioner submits that the respondents 3 and 4 herein, whose sale deed was subject matter of inquiry before the Assistant Commissioner, was executed on 31/8/1982. It is further submitted that respondent 3 and 4 had executed a sale deed on 17/10/92 in favor of Gangappa and Ranganna. And the petitioners were site holders who were purchased thereafter between the period of 2001
2017.
and 2017 sites in the said land, which is a subject matter of sale deed dated 31/8/1982. He submitted that even in so far as respondent number 3 and 4, in terms of the order at Annexure A, notice is served on the land. He submitted that as it was vacant land.
Your buildings are there kindly on the day. Exact position. Because layout was formed on the day.
Point is, it is served on the land. So if the land is vacant as on 82,
not 95, it is proceedings initiated.
As on 95, then
the
they will
layout
not.
Was formed, my lord. Layout was formed. Sold to various GPA holders. GPA holders purchased at that time. GPA holders later we purchased it from there.
Stated that now they were not residing in the land.
Now residing.
Owners of
not
respondent
residing,
3 and 4.
Not residing in that land.
It is stated that respondent 3 and 4 were not residing in the said land, and accordingly, it cannot be stated that there was effective notice. Next, even otherwise, it is submitted that in terms of the impugned order, notice though served, there was no representation, and the respondent 3 and 4, having given away their rights to power of attorney, have not evinced any interest in safeguarding the interest of the subsequent title holders. He submitted that proceedings were initiated in the year 95, 96 relating to the sale deed of 31/8/1982 beyond an unreasonable period of time, and such exercise of power ought to be set aside. Next, counsel for the petitioner further states that as on the date of initiation of proceedings, the sale deed was also executed in favor of Gangappa and Ranganna, who have all, as per sale deed dated 17/10/1992, and the said persons have also not been arraigned as party. Next.
1997 on judgment, my lord, I quoted in para number 22 of my ground. In 79 proceedings should be initiated within a reasonable period of 1 year from the date of initiation of sale deed. The judgment of 1997 Supreme Court, para 22, page 38, may kindly look at that. The Honorable Apex Court. The 79 is pertaining to 79 within 1 year, my lord, Supreme Court held.
79.
Please kindly, 1997 volume 6 SCC 71 Honorable Apex Court held. There is no limitation.
You have a copy.
Sumo motu proceeding should be exercised within a period of 1 year.
That is there. Where is this judgment refers to 79 AB?
No, sumo motu proceedings, whenever may be. Yes.
Next. Petitioner submit that in light of omission of 79A and B in the statute book, though there has been delay, as the order is passed in violation of principles of natural justice, as affected parties, even as on the date of initiation of proceedings, are not made as respondents before the Assistant Commission, and the order amounts to a nullity, may be set aside with a fresh opportunity to put forth a case before the Assistant Commission. The reference next. Peruse the order at annexure A. No doubt there is inordinate delay in filing the present proceeding. However, the contention that as on the date of the impugned order being passed, the purchasers who have rights already accrued in their favor ought to have been heard is required to be accepted. Even as on 17/10/92, Gangappa and Ranganna were the purchasers of the extent of land of 2 acres. They have also not been made as parties.
1 acre Gangappa, another person belonged by name Kempaya and Chikka Timmaya, 1 acre. Same date, same date.
Gangappa and Ranganna and
for 1 acre, and Kempaya and Chikka Timmaya for 1 acre of land.
Kempaya and Chikka Timmaya. Really good. Each having purchased 1 acre. This is next. Looking into the impact on the substantive rights, and also the delay in initiating the proceedings, and taking note of omission of 79A and B as on date, the entirety of the facts would make out a case for reconsideration by the Assistant Commissioner after notice to the affected parties. Accordingly, the impugned order is set aside. The petitioners to present themselves before the Assistant Commissioner without any further notice on 6th November. The petitioners to file an application for being impleaded in the proceedings, which may be considered so as to ensure that the petitioners are also heard. Needless to state, notices to the respondent 3 and 4 may also be issued by the Assistant Commissioner. The Assistant Commissioner, while considering the matter afresh, to take note of the contentions of unreasonable delay in initiating proceedings and other contentions that may be raised in the present petitioner's hearing, including the legal effect of omission of 79A and B. In light of the delay in referring the writ petition, the petitioners to pay costs of
1,000 each.
how much?
1,000.
1,000 each to the High Court Legal Services Committee within a period of
10 days.
10 days. Accordingly, petition is
Number 12.
Restoration of Mandamus.
yes. No, correct. No, I didn't get that. Now he is seeking restoration of the Pada. Huh? What are the facts? What are the facts?
But the land is declared as Mandamus. I have challenged so I have sought for the 2 prayers. That the entire declaration is I have challenged, and the alternative prayer is let them consider my the case in terms of the divisional judgment of the Sound Court.
Which one?
No, this is not sold.
This one. Which is citation?
Citation blood, AIR 2010, Karnataka 1449.
Copy. Which is the paragraph you are relying on? No, it's not sold.
Not sold.
If it's not sold,
They have to collect the arrears of revenue and restore.
terms of 5.1.
Yes.
When was it declared as Pada?
No, there is no date for that. There is no order also, Lord. They have to follow the procedure. They have not followed the procedure. Therefore, prayer number 1 I have started. However, Lord, division bench says that you, whenever the landowner come forward to pay the arrears of that revenue, you have to restore. And Lord,
No, but they are the you are the grantees.
yes, the original owners of the land. It is a Lord, your Lordship may kindly sing that annexure. Annexure came, Lord, page number 35, Lord, 36. Some of the persons have filed application seeking regularization. For that, Mulad Tahsildar says, no, it is a land. Therefore, their application cannot be considered. And I have produced the Mulad's EC, encumbrance certificate. There is no encumbrance. Tahsildar is the competent authority on 163.
Now, finally, the decision will be taken is to be taken at your end of restoration. Now they have rejected it, is it?
No, they have not passed any order. No, therefore I have sought for the.
So we'll send it back.
No order is.
Tuesday.
No purpose will be served.
No, Dana. The learned HCGP submits that they would verify whether any order has been passed regarding the request of the petitioner for restoration of Pada. Deals the matter in the same stage on 13th.
Some short date.
On 12th. You get oral instruction. If no order is passed, then we'll send it back to consider. Release the matter in the same stage on 12th. Right, 14.
Number 14.
Consider is representation for the purpose of conducting drugs. They have made in fact representation
as long back as in the month of May, and we have been in fact requesting the Tahsildar to do this northwest.
Okay.
They're all converted lands. These are all not agricultural.
It must be done by
Tahsildar.
how we'll dispose it of with the which we have been doing in other matters. There's a requirement, there's a circular of 15/10/22, which
In fact, we went and last occasion that submission was made, we went and inquired with the Tahsildar, who says not that it applies only for the agricultural lands, because in the computer the agricultural survey numbers are shown. So what cannot the non-agricultural lands, that is converted lands, there is no such survey number entered in the website. Therefore, they can't get. I have to physically, in fact, apply and get it done.
you find out. So their contention is land is converted.
No, Tahsildar himself says that
Correct.
physical application
Correct.
is
So
to be given.
you find out.
No, even if I'm required to give, I'll give. No, that's not a problem to file an application online.
No, but in case there is no
Sir.
provision, then there's no purpose of us directing online. So that you
Yes.
find out. We'll have it on Monday. Let them find out. I'll dispose it of.
Tahsildar himself told
No,
him.
correct, but I can't give a direction. Now, suppose I were to give a direction online, it will not serve any
No,
purpose.
online ಅಲ್ಲ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಅದು ಫಿಸಿಕಲ್ ಆಗಿ ಹಾಕ್ಬೇಕು ಬಿಕಾಸ್ converted lands ಅಲ್ಲಿ survey numbers are not reflected in the website.
Find out on
Therefore,
Monday.
we
We'll
have to-
dispose it of. Deal is the matter on Monday.
Regarding use, Tahsildar didn't proceed to evict.
Under Land Grabbing Act, he has to file a complaint. He will initiate the notice is one. So we can enter the.
Why you do this?
That was not.
No. This is not the why do they do this? If you're not interested, don't do it. Leave it like that only. Why you want to make a drama of issuing notice? Are you not aware of this act? No, then why all this drama then? Why they have to come to court again? It has to go back. There is no sincerity. I'm saying now, whether it's right or wrong, you follow the correct procedure, they will defend their case. Once the legal position is clear, and unlike we have changing rosters, Tahsildars don't have changing rosters. Even if they transfer, same roster, same benefits, same emoluments. Yes. So which section of the act?
Section 9 of the Act.
Section
9.
the section 9 is it?
Powers of the company.
Was at 758. Page number 758.
7.5.
9. Section 9. So it can also deal with civil matters
Yes.
under 9(4), isn't it?
Still number is, visual officer is, chairman of.
So we'll set it as aside, reserving liberty to take action. Otherwise, to have some training for them, have some training to tell them in case of encroachment, what are the options available. And then you can make one checklist and standard operating procedure. In case of Raj Kalve, what is to be done? In case of public lands, what is to be done? And so that there will be some guideline, and every time they need not come.
Connected matters to the Lordship of that an interim order. The Lordship has directed the government advocate to back to the Tahsildar. Despite of him communicating, proceeded and demolished the compound. That is very painful. In fact, I also spoke with him.
Can't take law into your own. What is personal interest you have? Of course, do it.
To portray it in the public domain that they have done for the great.
Or is it because of the petitioner? The present petition has been filed. Seeking for issuance of writ of certiorari to quash the notice at Annexure A, whereby notice is issued.
Also Annexure B.
Annexure A
And the order, subsequent order.
notice followed by the order at Annexure B. In terms of the order at Annexure B, the Tahsildar has found that there is encroachment of government land with respect to land bearing an extent of 6 acres, 7 guntas in new number 416, survey number 175 of Baglur village, Jala Hotli. On the basis of the report submitted by the Taluk surveyor and revenue inspector. And accordingly, it is directed for recovery of possession of such encroached land. But did you not bring this to the notice of the Tahsildar?
In these proceedings also, this was my contention that you have no jurisdiction. The second round of litigation part. The previous occasion on this had question that they had no notice, the Sun court disposed of the matter. Nevertheless, it was my case before this court that he has no jurisdiction, he lacks.
Land Council, appearing to the petitioner, submit that the Tahsildar has no jurisdiction to have passed an order pursuant to the notice at Annexure A, has all action for recovery of land encroached by private parties will have to be done by following the procedure under the provisions of the Karnataka Land Grabbing Act 2011. When such land, government land, falls within the jurisdiction specified under the Act. He submitted that the officer concerned is required to follow the procedure under the Karnataka Land Grabbing Act 2011. If at all, the officer is of the view that there is encroachment of government land, AGA submits that the procedure under the Karnataka Land Grabbing Act 2011 ought to have been followed. And once the specific procedure provided, and where the act would apply. Question of going back to the provisions under the Land Revenue Act, which would apply in normal circumstances, would not apply. Accordingly, the order at annexure B is set aside. Liberty is reserved to the respondents to take action as per law in terms of provisions of the Karnataka Land Grabbing Prohibition Act 2011. You make one SOP and it can be submitted either to the court while passing some judicial order or at the government level.
Can respond. Page 34 art. Page 36. That is that income is 2 lakhs. Average 5 years is 2 lakhs. So 79A is the correct. Second table at page 36. Total income is 1,52,000. This is the income tax returns it is including the agriculture. That has been overlooked by the second trustee. Has to be reconsidered by the second respondent.
When is that amendment to 25 lakhs? 13.8. So we passed that order. Pending matters also, you have to take note of 25 lakhs, isn't it? Srinivas Gowda. Huh? We'll have it tomorrow. Huh? We passed an order. I think Srinivas Gowda appeared in it. Just find out from him. You know, we have said it must be taken as 25 lakhs by virtue of the amendment. We'll have it tomorrow. Just find out. Release the matter tomorrow. Yes.
But directed the government advocate to check out this. The notice was served in the inquiry. The entire object section is platform. Expedition.
Annexure.
Speed. Page 18, my lord. That is the entire order from the beginning. Most of the time there is no booking, my lord.
There's no entry regarding service of note.
Particular property was purchased by selling my previous property just 10-15 days back.
There's no hearing also. On the first day, notice was issued on 8/12/2014.
Yes.
The next sitting directly posts it for orders.
For order.
But the order says notice is served.
Here it has been. It is a copy paste, my lord.
Now, where is the observation?
Observation is at the end, my lord.
Page 14. Page 14. Just above.
Inquiry into allegations. The authority proposed to duly served to the respondent. Respondent is that was the usual course of their order and usually in other cases what we have seen.
The petitioner has called in question correctness of the order at Annexure A, whereby the Assistant Commissioner has declared that the sale deed dated 26/10/2013 executed in favor of the petitioners herein, who were respondents before the Assistant Commissioner, is in violation of 79A and B of the Karnataka Land Reforms Act and is declared to be null and void. Thereafter, the impugned order directs the land to be, possession of the land to be taken over by the government. And counsel for the petition. But some costs you'll have to pay. In all matters, I'm imposing cost. It's more than 5 years. That's okay, but no doubt. But still, it's an order of more than 9 years.
No knowledge of the order.
RTC is when it was changed.
RTC when we applied, then only we came to know that there is an appropriate 70. I produced the RTC.
Correct. That last year, when was it changed?
Year 22 it was applied for. Then only we saw that Sakala.
Every year you must get, isn't it?
So what has happened is, in month of September we sold our land. What we had out of that proceed, in month of October we purchased.
Yeah, nominal cost. Counsel for the petition submits that the order is passed without service of notice and relies upon the order sheet, copy of which is produced at Annexure B, is submitted that though there is an entry on 8/12/2014 that notice is issued, except on such date, matter was adjourned on various hearing dates as on various hearing dates, but there is no entry relating to the receipt of notice and regarding its service. We submitted that the order sheet of a quasi-judicial authority must contain findings relating to service, which is absent in the present case. Though learned AGA were to draw attention to the findings in the impugned order at Annexure A relating to service of notice, the contention of the counsel for the petitioner requires acceptance. The quasi-judicial authority is required to maintain an order sheet which speaks for itself. Though there is an entry relating to issuance of notice, whether the said notice was served or returned is not forthcoming from the order sheet, and the order sheet of the authority must contain details as to the manner of service once it is issued by the authority, which is absent in the present case. On the sole ground of violation of principles of natural justice, order requires to be set aside. So far as the delay is concerned, counsel for the petitioner submits that they were not aware of the order passed as there was no notice. That AGA submits that revenue records were changed. And that should have been notice enough for the petitioner to come at the earliest point of time. As regards such aspect, taking note of the substantive rights of the involved of the parties and also omission of 79A and B from the statute book, it would meet the ends of justice by setting aside the impugned order on costs. Accordingly, the order at Annexure A is set aside, matters relegated back to the District Commissioner for first consideration, petitioners to be present before the Assistant Commissioner without notice on 6th November and place their case on merits before the Assistant Commissioner. Assistant Commissioner is to hear the matter on merits and while reconsidering the order, to take note of the legal consequence of omission of 79A and B. The petitioners are to pay costs of rupees 10,000 to the High Court Legal Services Committee. Where is the land? Bangalore North.
But it is still under litigation because it is not yet.
Legal services for yes. Yes, next.
Madam, lecture E1, page number 23, madam. Lord, 11, my lord, in schedule 4, bracket 2, serial number 26, the Tahsildar within 60 working days, Assistant Commissioner 30 working days, Deputy Commissioner 30 working days.
Schedule?
Sakala action 411, my lord. Schedule 4, bracket 2, serial number 26. Otherly 26.
That you consider and you pass orders. Whatever it is, you pass an order on the representation at Annexure E within a time frame in accordance with law. So what they are saying, under the Sakala Services Act, if it's not in dispute, it has to be disposed of within the 60 working days by the Tahsildar. So the same thing must be done. The petitioner. The sought for means of writ of Mandamus to direct the respondent number 1. No, we'll pass an order in all matters to follow the Sakala Act. In all undisputed cases, why they should come in writ of Mandamus? We'll dispose it of referring to the Sakala Services Act and says if it says within Tahsildar has to do within 60 days change of kata in undisputed cases, then you follow the time.
ಎಲ್ಲ ಸರ್ವಿಸ್ ಇದೆ ರೆವಿನ್ಯೂ ಮತ್ತೆ ಇದು ಕಾಂಪೋಸಿಷನ್ ಕೂಡ ಇದೆ ಅರ್ಜಿ ಡಿಲೇ ಮಾಡಿದ್ರೆ ಅಕಾಡೆಮಿಕ್ ರಿಜೆಕ್ಟೆಡ್ ಆರ್ ಅಲೋಡ್ ಬಟ್ ನಾಟ್ ಫಾರ್ವರ್ಡ್.
Section 3, every citizen has a right to obtain service within stipulated time. The petitioner the present petition has been filed Seeking for insurance. I'll have it at 2:30. Have a look at the provisional Sakala Act and make reference to it. I'll dictate it and I'll consider reporting it so that in other matters also it will be. 2:30 or tomorrow. Tomorrow will have. This is the matter on top of the preliminary hearing list tomorrow. You want to ask Madheshwaran also to look into it and look into the Sakala services.
This is scheduled for bracket 2, item number 26.
Tomorrow you come. Relist the matter tomorrow.
Matter will come up. Not that the comfort of the demolition of my house. Yeah, this man. Protection.
Yes. Whatever you take, at the culmination of the proceedings, you can take action. The petitioners have sought for issuance of writ to restrain the respondents from obstructing and interfering the scheduled property belonging to the petitioners. The counsel for the petitioner submits that the petitioners are owners of the property in survey number 57 of Kagalahalli village, Harohalli Hogli, Kanakpura Taluk, Ramnagara district, measuring an extent of 6 acres, 14 guntas. It is ancestral property of the petitioners. It is submitted that upon demise of Nanjappa, petitioners who are the legal heirs have continued in possession and have constructed a house on the northern side of the property, measuring an extent of 2,000 square feet. Further submitted that on 21/9/2023, the respondents have entered in the land of the petitioners along with jurisdictional points and threatened to demolish the house in the scheduled property on the ground that the house had encroached upon government road. Petitioner submits that no notice has been issued to the petitioners prior to the authorities entering into the property of the petitioner, and that the allegation regarding encroachment is a matter that could be contested and clarified if opportunity is given to the petitioners. HCGP appearing for the state, upon instruction, submits that there is an allegation regarding encroachment of government road, but however, they would follow the procedure prescribed in law in taking action against the petitioners. In light of the said stand, the petition is disposed of. The respondents are restrained from interfering with the rights of the petitioner, except by following due procedure prescribed under the relevant act, insofar as the allegation of encroachment. Needless to state, no precipitative action can be taken till the conclusion of the proceedings to be initiated by the respondent, wherein an opportunity is to be afforded to the petitioner to put forth his case. And it is only upon conclusion of proceedings to be initiated that necessary action will be taken in accordance with that. Accordingly, petition is disposed of.
This is a case where
Let us see what it is.
I'll just make a submission. That the land is re-granted in favor of the petitioner by the special deputy commissioner. Parinam's khata has been affected. Before the deputy commissioner, statements have been made by the two landlords earlier who sold the property to us on 30th of June 1958. Based on the sale, the re-grant order was made. Statements have been made by the Tahsildar, by the two owners, the Inamdar, and the neighbors, stating that it is Kimarayappa was cultivating the property, the father of the petitioner. Now, my lord, a suit for injunction was filed in 2014. That came to be rejected. We filed an appeal is pending. Then IA 2 of 2020 was filed. There is a direction it should be heard along with the main matter. That suppressing the fact that the IA has been rejected, the respondent filed an injunction suit during the pendency of the appeal, and ex parte injunction has been granted. We moved an application that was converted into status quo. After hearing, injunction has been granted. We filed an MFA. In the MFA, the respondent gave an undertaking that will not proceed with the construction. In spite of the undertaking, they proceeded. Then this court passed an order, my lord, the status quo order. My lord, the final matter was hotly contested. In the MFA, the finding is during the pendency of the appeal, construction shall not be permitted because it alters the character of the land and the position is irretrievable.
What are the page?
My lord, paragraph IA number. My lord, along with the IA, para 29 if you want to get page 44. Now, my lord, four lines application. IA 3 today, my lord, we filed an application. On 29 September, on 28th, we have been arrested. Houses have been demolished. 200 people. We have got the entire video cup. And page 44, in page 44, paragraph 29. It is also not in dispute that the appeal is pending for consideration, and under the statutory appeal, this court has to consider both factual aspect as well as question of law and reappreciate both mixed question of fact and law. Though the suits are filed by both the appellant as well as the respondent hearing, I have already pointed out both the suits for the relief of injunction, and both of them have not claimed the title in the respective suit. When such being the case, when the issue is pending before the court, under the statutory appeal, the matter has to be reanalyzed by this court. The relief is also sought before the trial court by the present respondent not to interfere the construction work. The judgment relied on by the appellant in case of Anil Metaclass Private Limited referred to the apex court held, if any construction is made and the same would amount to change the nature of the property, that cannot be done when the appeal is pending before the court. The material discloses that based on the interim order obtained by the respondent before the trial court, they started construction work, and before this court, they have given an undertaking. They are not going to continue the same, and thereafter, when such an undertaking was given, in spite of it, when they continued the work, and the same is brought to the notice of this court, and this court directed not to put up any construction. In the other judgment, the apex court has done so.
go before a different bench.
Pardon,
Has to go before a different bench.
RFM. The order is
Just-
passed on 4th of August.
Just 1 minute. Has to go before a different bench. Some disability.
Pardon,
There is some disability.
yes,
This is the matter, not before this the matter, before an appropriate bench. After obtaining necessary orders at the earliest, in light of contention raised by senior counsel appearing on behalf of appellants in RFP 1060, that the application for temporary injunction requires to be considered immediately. The office to make an endeavor to place the matter of appropriate orders before bench by tomorrow.
please.
There you ask.
This is hijacking the orders of this court.
Ask before the vote when it comes. Yes. ಯಾವ್ದು?
Same matter, he is the advocate of the court.
Office to show name of council as PB Kalpana instead of PB Kalpana, or else there will be defamation. Already on it. Lord Council G.R.S. Hegde has filed memo of retirement and seeks to withdraw from prosecuting proceedings on behalf of R1 and R2. Later, the council Shri Pradeep Naik, already being on record, memo of retirement is accepted and the office to delete the name of Lord Council Shri R.S. Hegde as representing R1 and R2. This is the matter week after next.
The connected matter, my lord, is 37 matter.
Along with the WP number, so and so. Right.
Previous matter. Filing the two orders filed by the Lord Justice Karnataka, quashing the criminal proceedings. By filing in office, not data, and violation.
What is that?
That is the two orders and the complaint to the police station.
Memo. No file. Taken on record. Sign. Training. Serve it on the others.
Please.
Government.
4 to 5.
Yes. I can't recall the facts. They dictate a note on that day. No? Just on this. I'd also asked you to find out whether you can withdraw it, isn't it? Correct, but whether it can be done at this stage. Okay. So what we can do, we'll send it back to the KAT after setting aside the order, asking it to revisit the aspect of locus standi of the appellants having already suffered an order. There, if they want, let them withdraw it. Their information. Correct. Now, whether he has the locus to have challenged when their rights have attained finality by rejection of appeal 120 of 2015, let the KAT examine it. Correct. Correct. So, going further, so we'll say after having recorded that finding, question of entering into appeals technically did not arise. That's what I want to know, whether they can seek for withdrawal. So otherwise, we'll make this observation and send it back, because admittedly there's a finding that they have no locus. If that were to be so, going further on merit would not have arisen. So we'll send it back. There, if they file for withdrawal, it's up to them. Now you have not challenged, isn't it? Nature. Power is vested with In Arms Act, again, it's DC, isn't it? In effect, that is the stand. In effect, if matter is allowed to rest by virtue of their settlement, then what will happen? Correct. That order will set aside on the ground that once there is no locus for the respondent 5 to 8 in view of disposal of appeal 120 of 2015, they could not have challenged the order before the KAT as their rights have extinguished. Then it was a matter between the state and the petitioner here. So it could not have been entertained at all at their instance. When that is held, then the order of the KAT will go. Then what remains to me? Now, if the KAT appeal is rejected, let's assume. So then they may withdraw it before the KAT. We leave it to them. Then, in case KAT permits, there ends the matter. If you object, the KAT will decide. We'll send it back. Huh? Just one. Just one. Yes. That legal, if you want, I'll have it on Monday. You examine the legal position. No, you examine. You must help her. Unless there's no free lunch, you must do your homework. You get some judgment. That even in a writ. No, correct. No, that's why I'll send it back to the KAT. There you work it out. You withdraw it.
Send back to the matter to the KAT. It is settled because the other side is accepted.
There is some state will have to take. She will not be in a position to take any stand. If I send back to the KAT, your appeal, you withdraw it. Nobody can object. You want, I'll pass over. You make a submission, I'll send it back. You discuss with your friend. Correct. You discuss with your friend and you take a stand. I'll have it at 2:30. You discuss with your friend and you make. Monday. Before change of roster, you take your order. Relist the matter on Monday. Good. Suppose the order goes, then that finding also will go. Then it's open for them to whatever to withdraw. No, that let them take. If they're going to contest it by relying on the same judgment. You have a look at this. By virtue of which the DC order will have to be set aside. Have a look at it. Relist the matter in preliminary hearing list on Monday. Preliminary hearing is earlier to that.
Yes.
Is the matter week after next.
That is the order back. State Commissioner has annexed page 93. Petitioner's father may not purchase an acre of land. An acre of land in year 1970.
What is 97?
97 is the order passed by the State Commissioner. Directing to delete the name of the petition from the RT.
no inquiry is able, no notice is served, my lord. In the year 1987 itself, the land was converted.
What is the power of the AC now?
Not AC impact had no power, my lord.
Order
Pass
for
this
deletion. That power is only with the Tahsildar.
The Tahsildar, my lord. It is only for rectification of the RTC.
Right. Did anybody file 136(2) before the AC?
No, my lord. There is no application for the 136 before the years.
The special Tahsildar appears to have made some report of 17/9/2019, page 97, annexure K reference. They are saying if it is to be treated as 136(2), if it is treated on the basis of a report at reference, even then there must be an inquiry.
Lord, even to initiate inquiry, my lord, at in year 1987 itself, the land is converted.
Converted. 1987.
1987, with the order of deputy commissioner. Lord, I have produced it at annexure E, page 58.
Land measuring
Out of 1 acre 16 quotas, 1 acre 1 quotas was sold. Year 1980. Thereafter, in year 1987, this remaining 15 quotas was converted as per annexure E.
we have it at 2:30 or tomorrow. Now we'll only on this point that it is converted land. Annexure E, they don't have the file, we'll have it tomorrow. And so only on this point that because it's converted, there's no jurisdiction. So if it's converted, then remedy lies before.
Lord, what the assistant commissioner has done.
No, I'm on the point. If the land is converted, just suppose the land is converted and there is some dispute, then they have to go to the municipal authority.
Land has been assessed by the BBMP.
EBA. It's under the Municipal Corporations Act. So after 87, the authorities under the Act will cease to have jurisdiction. Just point out the provision also of the applicability of land revenue. Relist the matter in preliminary hearing list tomorrow. Only on that point we'll check it as. Is there no contesting party? No. Yes. Next week. At request made on behalf of the respondent. This is the matter week after next. Yes. Adjourned it. Adjourned it. They want it next week. Let it come week after. In the week commencing from 30th. Interim order. Earlier grant is extended till the next date. Yes.
But I have objections.
Okay, file it. File it. Oh, you have filed that. Copy of objections to be served on counsel for the impeding applicant. Right. Let us see, it's only impeding. Matter is pending. Let's see. Annexure?
Page 58.
Just 1 minute. In that matter, you find out what is the provision that limits the jurisdiction of proceedings under the Land Revenue. Annexure?
Annexure K, page 58.
Yes. And both of you are claiming, is it? Has been granted, and that is not that has not been cancelled. 9.5. That's pending consideration. That order was set aside, is it? You are children of Polanna, is it? You. What is your case?
If I may, Lord, this case, what had happened? Lord, originally, I am also a landless person, Lord. My land has been, Lord, acquired for construction of Chakra Canal project. Lord, initially, the dispute, the land which is in question, Lord, was granted in favor of the impleading applicants herein. They were not in possession of the property. They were not cultivating the property.
Anyhow, that was cancelled.
No, Lord, that was cancelled. At that time of cancelling the proceedings, I got impleaded in that, saying that from that point of time, from 1978, I have been in possession of that property. Even I'm a landless person, and please grant this land in my favor, because he is not in possession. And thereafter, that in 2010 order, his grant was cancelled.
That was challenged before this honorable court in Annexure K, that is WP 9506 proceeding, page Annexure K, page 58.
Correct. There
they dismissed the petition.
upheld the cancellation.
Upheld the cancellation.
And then
they say liberty is given because he is also has lost the land, so land can be given to him. Now, what had happened? My specific contention before this honorable court at that point of time also. Lord, my objection, my lord, is that Annexure K, page 52, which I had filed before the earlier proceeding. There I have been arrayed as respondent number 6. That I am in possession of the property, though land is not granted in my favor, I am seeking for grant of this land. Thereafter, my lord, proceedings have happened before the deputy commissioner itself. Kindly see, my lord, Annexure P, page 79. Now, because the situation is, my lord, that his grant is cancelled. I am in possession of the property. I have sought for grant of that land because even I have also lost the land under rehabilitation. My lord, page 79, my lord, the proceeding was done by the deputy commissioner and it was forwarded to.
Yes. So now you're saying there's no overlap, so it is not necessary.
Yes. The question of overlap does not arise. Yes, Lord.
That is your case.
It is tit for tat, Lord, because I got implicated in that proceeding, and because of that, expedition got dismissed. Now he wants to get implicated in this proceeding.
So now you are right for alternative land.
I'm not
just one. Your right for allotment of alternative land is still pending. They have not yet given. They have not yet given. No, just 1 minute. Just 1 minute. Now you have filed any mandamus? No.
Actually, L page 66.
Okay. They have not complied. But now, what do you? Why are you entering into this litigation? No, now your grant has been cancelled, isn't it? And you have been given direction for alternative land. That alternative, huh? Cancelled, no? The cancellation is upheld by the single judge. Same village. Where survey number? How can you ask for survey number? That land cancellation has been upheld. In the same village, you can ask. But you can't ask where he's asking. No, that may be so, but both of you cannot be given the same land. Let us see. After vacation. It's the matter after vacation. Intimate earlier grant is extended till the next. List the matter in the week commencing from 6th.
December 27, my lord. Notice in respect of respondent number 6 may be dispensed with, my lord.
Notice I have dispensed with as regards respondent number 6. At risk of the petitioner, file a memo.
Yes, I will file a memo. All file.
The other side is not there. List the matter in the week commencing from. Yes.
Yes, an IA formula like pleading respondent Tahsildar and the land grant committee for the necessary parties for our petition they have not paid at the party.
The AG is directed to accept notice.
Another IA filed by me, Lord,
This is a subsequent development after filing of the
We'll allow it. We'll allow it. Filed under Order 1, Rule 10, seeking to implead Tahsildar and the Regularization Committee. Said taking note of the governments. The application is allowed. Necessary application is allowed. Necessary amendment to be carried out. AG accepts notice for the Tahsildar and the committee, who are now arrayed as additional respondents. IA 1 of 23 is IA 1 now. 2 of IA 2 of 23 impleading. IA 1 of 23 has been filed, seeking to raise additional grounds. Neither the facts made out, said application is allowed. Amended petition to be filed. This is the matter week after next. Yes. You have to file amended petition and amend it. Put it, fine. Office objections to be complied with. Office to notify after a date, after such office objections are complied with. Notify date of hearing to the party in person. Each time granted for necessary compliance. Same order. You serve it, place it on record. So what is the direction sought? Drainage system. So what is the report? They've removed. Place it on record after serving copy. Learned IGA submits that a report would be filed after serving copies on other side. Relist the matter. They'll give it to you. They'll give it. Relist the matter. 6th of November. Affidavit.
Kindly pass out the matter.
Still to file affidavit. Affidavit has contemplated in the order of 1823 to be filed. Relist the matter.
Similar matter.
Affidavit at 13th. Let them file the affidavit. Let them file the affidavit. Once they file the affidavit, what stand they're taken, then we'll see what is to be. Next week is 13th.
I'm challenging the annexure A and B minutes. And annexure B minute, he both responded. And one teen again.
Why is it come in the orders list?
I'm looking in interim already taken notice of it.
4 to 9? 4 to 9. Notice.
ಅದಕ್ಕೆ ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ? ಯಾಕೆ? Notice is not served to 4 to 9.
ನಮ್ಮ ಪ್ರಕಾರ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಬಂದಿಲ್ಲ.
ಸರ್ವಿಸ್ ಆಗಿ
ಸರ್ವಿಸ್ ಆಗಿದೆ. ವೆಂಕಟರಾಮನಲ್ಲಿ ಆಗಿದೆ.
Sakala stated to have been filed for the private respondents. This is the matter next week. Date the orders list 11th.
Owner of the property, survey number 262/3, measuring 1 acre, 9 guntas per acre. Out of that, he sold the property of 25 guntas and he retained the property of 23 guntas per acre. But the revenue records are not changed in respect to 23 guntas. Subsequently, the petitioner has filed an representation by seeking the change of revenue entries to his name. That is referred to the revenue officers also submitted the report to that effect and sought permission from the assistant commissioner. The assistant commissioner has rejected the claim of the petitioner by stating that the title deed is not produced. In the meantime, the uncle of the petitioner, the fifth respondent, has filed an application stating that he is the owner of the property. And without producing any documents, the assistant commissioner has directed to effect the Tata in his favor and revenue entries. For that, the petitioner has challenged the same before the deputy commissioner. The deputy commissioner, without producing any documents, has rejected the petition of this petitioner. For a moment, your lordship, I kindly see the annexer C, page number 25, annexer C. That is the original sale deed, in that. In the page number 26, your lordship may find that,
No, revenue entry has been cancelled.
Revenue entry is not cancelled. The direction to enter the name of my uncle.
Correct. Now, as on date, in whose name it stands?
Now it is changed to the name of my uncle.
Correct. So let notice be served. After I come, we'll see what is to be done.
Please, any judgment.
Notice. Emergent notice to respondent number 5. EJ accepts notice for respondent 1 to 4. This is the matter in the week commencing from 30th. 30th, huh? In the this is the matter 3rd November 1st. The week commencing from
Number 33.
we have adjourned it.
Please look, there's one submission I have to make. I just got the instructions from the client that STRR has intimated a notification has been issued with respect to this petitioner's land, what they had now in CDP shown as 1 acre as towards road. Now they've only taken 4 guntas as by virtue of activation. They've issued notice to the client. Only 4 guntas has been taken. Therefore, the government has to now clarify because they now sought to intend to acquire only 4 guntas out of 1 acre. They can give a conversion for the remaining extent of land. I'll just hand over the notice that is ready.
That is the order of your cousins only, no? Cousin or brother? Blood brothers.
4 guntas only is now sought to be taken. Lordships may take the second silver ke patra.
They are cousins only.
Lordships will see down, watermelon. 4 guntas.
Page?
Lordships will see, I'm sorry, there's no page. The second page.
8.
293/2. Only 4 guntas is sought to be acquired.
Leaving out this, you have no.
I have no objection, Lord. I have no objection. If they can convert the land leaving this extent, I have no objection. And in case if they want to put a condition that in future, if they want to acquire or widen the thing, they can pay compensation whenever it is they can't, but keep a rider for 20 years that I cannot develop my land.
This is respondent number. This is the authority.
The authority.
So now they want to acquire only 4 guntas. Correct. Now they want to, that is the special land acquisition office. So they want to acquire, as of now, 4 guntas. No, correct. So now what they are saying, now that has remained since long, isn't it? Now he is ready to give an indemnity bond, saying that in the event there is any acquisition. Right, but we can't keep it permanently later. No, that's why now that affidavit we have directed, in light of this, you file the affidavit.
That's what I wanted to make a submission. Light of this, let them.
Yes. The counsel for the petitioner has filed a memo along with the, you correct that memo.
Please, I'll make a page number.
No list of citation. Communication. They has produced 2 communications dated 23/8/23 and submits that by virtue of the communication of the special land acquisition officer, insofar as the land in 293/2, survey number 293/2, what is now proposed to be acquired
Please,
is 0.04 acres. And accordingly, he submits that the authorities may now permit conversion of land, and the petitioner is ready to undertake by way of indemnity bond as may be directed to be executed, that in the event of acquisition, he would be subject to the acquisition process while reserving his right to challenge the same in accordance with law. The affidavit as directed on 1/8/2023 to be filed is now to be filed taking note of the documents filed along with the memo.
copy served to them.
Along with the memo. We relist the matter on 13.
Grateful.
No, now, if what is going to be acquired is that without making it a precedent, now you can't, now suppose master plan doesn't change because they're before the Supreme Court, isn't it? Huh? Then you ask the government, find out from the government what is their proposal, why they have said only 4 guntas.
PRR has done the alignment and survey a lot. Accordingly, they have seen and they've taken 4 guntas.
Yes, next. Yes,
Petitioner and the fifth respondent are brothers.
Curator is served. Injunctions filed by respondent number 5. It's taken on record. ಅಲ್ಲಿ ನೋಡಕ್ಕೆ ಏನ್ ಟೈಮ್ ಬೇಕಾ ಅಥವಾ ಶುರು ಮಾಡ್ತೀವಿ?
Pressing for the entry.
Okay, what is
A request to come to the case is this. It is the case of the petitioners that they are the owners of 34 guntas in survey number 30/2. Fifth respondent claim is that he is the owner of 30 guntas in survey number 30/1 of Mahantalingapura village.
30/1 measuring
30/1, fifth respondent,
measuring
30 guntas. Petitioners claim 30/2, 34 guntas. May I request to come to page number 34, annexure F.
now your claim is on the basis of sale deed or
Will. And subsequently, the first petitioner gifted the property in favor of the second petitioner. Now, the revenue entries stands in the name of the second petitioner. May I just,
as on date.
as on date.
Mutation is affected. Mutation is affected.
Yes, sir.
Yes.
May I request to come to page 34, annexure F, RTC.
Yes.
It is regarding 30/2, which was standing in the name of first petitioner,
Venkatesh.
Venkatesh.
Yes.
First petitioner, to the extent of 32.
34.
34 guntas.
Yes.
Now I request to come to page 46, annexure J.
Now that mutation is 2014-15
Yes, yes.
by way of partition.
Yes. Now I request to come to the next page. That is the gift deed. Who gifted the property in favor of the second petitioner? First petitioner gifted the property in favor of the second petitioner. Now the annexure J, that is the RTC.
Page?
Stands page 46.
That has also been changed.
Yes. Changed in the name of the second petitioner.
The basis of the gift deed.
Gift deed.
Then what happened?
Now I request to come to the page number 70, annexure M.
Now this is 30/P4.
One, yes, P1. That is with respect to property of fifth respondent. So far as his land is concerned, RTC is also stands in the name of the fifth respondent.
30/P4.
P4 anta ide, but it is 30 guntas. It is the land of the fifth respondent. So RTC stands in the name of the fifth respondent for his land. And RTC is also stands in the name of the second petitioner for her land. The fifth respondent made an application before the state commissioner for cancellation of mutations mutated in the name of the first petitioner by claiming that he is the owner of the property of 30/2. So accordingly, my mutation is directed to cancel the order. It is at page number 11, annexion A. Operative portion, relevant para is at page 19.
Yes.
In para
11, it is observed that in the middle of that paragraph, the second respondent.
Read the whole paragraph.
Yes. Further, on perusal of the Akar Band, it shows that new survey number 30/2 has not been assigned in respect of any portion in survey number 30, much less the alleged 34 guntas, and hence it is very clear that survey number 30/2 is not existing. And therefore, the order of mutation number P/17 of 2014-15 is illegal and not valid, and consequently, the second respondent has not derived any right, title, or interest over the any portion in survey number 30 or non-existing survey number 30/2, measuring 34 guntas of Mandamus village under the said gift deed executed by the first respondent, and hence the mutation effected in the name of the second respondent wives is also illegal and not valid. Hence, both the imputed mutation orders are liable to be set aside. Now, accordingly, this is the order of so is set aside. That the Tahsildar Anekal Tala Danekal is thereby directed to cancel the RTC in respect of the land in survey number 30/2, measuring 34 guntas situated in accordance with law. Further directed to generate and continue the RTC in respect of the land in survey number 30/1, measuring 30 guntas situated at Malingapura village in the name of appellant in accordance with law. So it is directed to continue in the name of the fifth respondent and cancel the RTC in the name of first petitioner. As against the same, I have filed the petition, revision petition. This is at annexure B. Admittedly, there are suits.
Just no, if according to you, 30/2 doesn't exist, then you have to initiate proceedings for correction of revenue entries under 136(3), and then you can go for cancellation of the mutation. Without, now suppose you had to say 30/2 doesn't exist when latest Pani is there, you have to cancel it by 136(3) after notice to them, and then you can take steps to cancel the mutation. No, correct. I'm just saying now, as on date, in whose name whether it has been deleted or not.
It is not yet deleted.
No,
May I request?
Just 1 minute. Let there be an order of status quo as on date. File your objections and have it in B group. We'll hear the matter. I'm not going into the merits, sir. It's now at the admission stage. You'll have to hear it in B group. This stage, I'm not going to hear it.
That is the reason. This property is acquired by my father. There is a partition where registered partition is number 1. That is the registered partition. And the registered partition is particular property is part of my share. And based on the registered partition, revenue entries are transferred in my name. Again, number 30 was the order. Except this property, which is acquired in the name, our property doesn't have any property at all. But by stray entries, by after partition, the first petitioner goes to the revenue authorities and made a representation, transfer the data on the basis of how he was. Though there was a partition, and there is a partition, registered partition. Based on that, I have initiated the criminal proceedings. Now, what he is trying to say, he says that I am the owner of 34 guntas and something of 30 now it is assigned. But the boundaries remains my property. And what has happened? What I have initiated the criminal proceedings. This one he has created a bill. Said to have been executed by his father in law, by Amal Sufficient, kindly come to pay over the document. What is this sort of time? How my father has acquired property? Not away. Only property we have purchased, except 30 guntas. Now he says that he is saying by mistake it is mentioned as 30 guntas, but the actual extent is 34 guntas. It is subject to the partition. And the partition, I know what is this right? Let me establish how his name has entered in the RBC. What is the basis?
Right. What I'm saying, we'll hear that the government also take their stand. We'll have it in B group.
As the interim order is concerned, now, prime office doesn't have any case because it's a created document. That is the reason he has been charged. Now, by creating a bill, now he has conveyed the property.
What is the suit? What is the suit?
Suit for permit.
That is pending.
I have also filed his two suits.
Permanent injunction. Survey number is 30/2 is mentioning. Actual survey number is 30/1. Other survey number was 30. After putting this particular land design is 30/1. No such property 30/2. So now she has filed after the virtue of the GP. She has filed a suit for bare injunction, which is also pending consideration. My difficulty is not in respect of my property, which is mentioned in the partition deed. He is also party. He has been allotted other property. And mentioning my family is public. That is the difficulty.
Let the state file. State to file.
And my only submission is there any basis for him to enter the revenue administration or whatever? That is only.
That will hear. We'll hear it, but we have to maintain the status quo. Now, if it's cancelled, what remains?
My submission.
Let us see. Correct. It requires a hearing. That's all I'm saying. It's not that we can decide it at this stage.
Status quo.
Yes. In respect of what he is claiming.
30/2.
The state to file their statement of objections insofar as in light of the observation made at para 11 of the order of the assistant commissioner. In the interregnum, there would be an order of status quo insofar as revenue increase in respect of 30/2, measuring 34 guntas of Mahanta Lingapura village, Anekal Taluk. Statement of objections filed by respondent number 5 is taken on record. This the matter in the week commencing from you request for dates, you can, I told the court officer, you can 2:30 make a mention.
What officer?
ಹೇಳಿ ಸರ್.
Serial 53.
30th ಸರ್, 30th.
ಡೇಟ್ ಹೋಗಿದೆ ಅದು?
30th ಸರ್, ಹೌದು 30th ಸರ್.
ಸರ್ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಾ ಇಲ್ಲ?
ಇಲ್ಲ ಈಗ ಸರ್, ಈಗ
ಡೇಟ್ ಸರ್ ಬೇಡ ಸರ್, ಡೇಟ್ ಕೊಡ್ಬೇಡಿ, ಅದನ್ನ ಹಿಯರ್ ಮಾಡಬೇಕು.
ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗಲ್ಲ ಸರ್, ಯಾವ್ದು ವಾಟರ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ
ಸರ್. ಹಂಗಾರೆ ಡೇಟ್ ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್, ಅದು 30th ಬೇಡ.
ಶಾರ್ಟ್ ಡೇಟ್ ಇಲ್ಲ ಸರ್, ಅದೇ ಲಾಸ್ಟ್ ಇನ್ನು 25, 26, 27 ಇಲ್ಲ, 30th.
25, 26 ಕೊಡ್ತೀರಾ
ಸರ್? ಅವತ್ತೇ ಕೋರ್ಟ್ ಓಪನ್ ಆಗುತ್ತೆ, ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ತಗೊಳಲ್ಲ ಅವತ್ತು. 30th ಮಂಡೇ ಮೇಲೆ.
30th.
Online. ನಾವು ಮುಟ್ಟಂಗಿಲ್ಲ. FR number or regular number? ನಾವು ಮುಟ್ಟಂಗಿಲ್ಲ. Online ಮಾಡಿ immediate SMS will come. Online ಅಲ್ಲೇ ಮಾಡ್ಬೇಕು. Online ಮಾಡ್ಬಿಟ್ಟು SMS will come to you direct. That is the ನಮ್ ಕೈಯಲ್ಲಿ ಅದನ್ನ that power has been taken away except end of list. All must go. They're doing some experiment. They want to see how it works. Correct, but we are not permitted to give any on memos. It's being computerized ಅಲ್ಲಿ ನಿಮ್ಗೆ ಕಳಿಸ್ತಾರೆ. ನಾನು ತಲೆ ಬಾಗ್ಬೇಕು. Correct. FR number ಮಾತ್ರ you can move them. Yes. ಇದೇನು ನೋಡಿದ್ರಾ? Next year. No. So Ramaya was the occupant, tenant. But they are challenging that 75 order now. The petitioner herein calling question the correctness of the order passed at annexure A in case number so and so. Disposed of on 25th June 1977. The petitioner herein was a claimant of tenancy occupancy rights. The petitioner herein is the son of the applicant before the tribunal who had claimed occupancy rights. It is to be noticed that in so far as the first applicant's claim challenged by way of writ petition 40971 of 2019, same came to be rejected as per order dated 5th November 2019, primarily on the aspect of delay and latches. Observations relating to the rejection of the first applicant's claim are as follows. 6 to 60 length. It is fairly submitted by counsel for petitioner that the case of the petitioner is no different from that of the Ramaya. The order in writ petition 40971 of 2019 was confirmed by the division bench. WA 4044 of 2019. We find no reason to take a different stand. And accordingly, the petition is rejected after taking note of observations made in WP 40971 of 2019 as affirmed in WA 4044 of 2019. Office objection, you will comply. Wakalat. So far as office objection seal number 1, same is overruled. Insofar as office objection and seal number 2, petitioner submits, the same would be complied within 2 days. The petitioner sought for issuance of writ of Mandamus to respondent number 4 to place petitioner's application before the 5th respondent. The petitioner submits that petitioner has filed Form 57 seeking regularization of unauthorized cultivation. Copy of the copy of the form is enclosed at annexure B. In light of the limited period sought for, we take note of the observations WP 186AQ of 2023. And then Lord AG submits the taking note of the observation in WP 186AQ of 2023. Present matter may be disposed. Observation made in WP 16862 of 2023. Extract para 3 and 4. In light of the same, once the committee has contemplated that Roman 1 is constituted, applications to be placed before the committee and by the Tahsildar. Respondent number 4 and same to be disposed of in a further period of 6 months in terms of direction at Roman 2. That Wakalat you complete the office of protection till then. Needless to state, till such an application is disposed of, there could be no action taken to dispossess the petitions. Yes. Column 11 ಅಲ್ಲಿ. What is the procedure? What is What does this say? Para? Within 2 weeks from date of receipt of order. We can extract paragraph. Paragraph. Seven and 8. 7 and 8. The petitioner has sought for issuance of writ of Mandamus to consider representation at annexure D, D1, D2, D3 as regards respondent number 1, 2, 4 respectively. Only regarding entry will make an order. Only that will consider. The counsel for the petitioner submits that insofar as survey number 42/2 of Chikkagubbi village, Bidaralli, Hubli, Bangalore East Taluk, with respect to an extent of 2 acres, 17 guntas between the petitioners and other private parties in OS 1294/2023. An order of injunction has been granted. Annexure copy of the said orders produced at annexure C. It is submitted that petitioner sought by way of representation for making entry in columns 11 of the RTC as regard the interim order passed. And despite such representation, no action has been taken. DG submits that necessary action will be taken and the representation be considered. This court in WP 10943 of 2020, while considering a similar question relating to entry in column 11 regarding orders of courts, has disposed of the said writ petition and relevant observations as far as 7 and 8 reads as follows. 7 till last month reads as follows. In light of the above legal position, the respondent Tahsildar has no discretion but to make entry relating to the interim order passed in column 11 of the RTC. Accordingly, petition is disposed of. The respondent number 1 is directed to take note of the subject matter of the request and in terms of the observations made in WB 10943 of 2022, take necessary action to make entry of the interim order passed in column 11. Such process to be completed within a period of 3 weeks. 2 weeks from date of receipt of certified copy of the order. Just 1 minute, just Gautam. Huh? Please start Dasara vacation. All ಈ ಕೇಸಿಂದ ನಾನು ಬಿಡುಗಡೆ ಮಾಡಬೇಡಿ. Finish it, whatever it is. Suppose you have to accept that the alteration made is in accordance, then the case closes. ಆಯ್ತು ನೋಡು. I don't know where I'll be. ಇಲ್ಲಿ ಇರ್ತೀನೋ ಬೇರೆ ಕಡೆ ಇರ್ತೀನಿ. So I've adjourned it and we'll fix it. But let them, you follow up with them so that if it comes to that stage, we can. So by Dasra, you finish. Either way, now suppose it's not, then the matter will have to be heard. But suppose on the other hand, you have to accept it, then it comes to an end, isn't it? Then you follow up with them.
In respect to 9549 of 2020.
But government will have to say something or unilaterally. We can forewarn them if they have to take some stand in this matter. Government, whether government stand is required, we can, if it's required, we can ask them that at the end of it.
Government has been sleeping all the way, 35 years. They have not taken a stand. I don't think they don't think. Tenure, it's a case of rival tenancy. Question of government taking a stand. They have not disputed the fact that it is a tenant. So the vesting is there, the government is benefited by the order of the tribunal. This is a petition filed by.
The reason why during the course of arguments, we noticed that there were some documents when the government says that the MUT can claim it, etc., etc. So if it is, unless it is a Muzrai or government control, I asked in the course of argument what the government has to do by saying that MUT properties must can be claimed by them, etc. So if at all the government has to have a say. Yes. They must not be taken by surprise on the last day. What do you have to say? Stay.
First time all the lands are was the subject matter challenged by the state. Even all the outside the order different days, and it was not heard as all the days there was no challenge. Except that
Yeah, they will have to break their silence. Yes.
Over this petition, that is petition 9549 is concerned. Now, all these submissions I have made yesterday in respect to the other petition. They apply to the facts of this case as well.
You made submissions in?
Yesterday, I made submissions in the other petition filed by Mr. Ramakrishna. These submissions are made in Sharama. Sharanabasveshwara Vishwaradhya Shivacharya Swami. That is 9549. So delay and lack of it applies to this as well. And res judicata, it applies with greater force here. Now kindly permit me to show the prayer that is made in the written. This court has already noticed the fact that pursuant to the writ appeal orders that were made earlier, the limited scope for the land tribunal was to find out whether Bailappa has withdrawn the application or not. Bailappa's withdrawal is now confirmed. Now, what is it that is challenged here? Kindly by Guru at page 18. Therefore, it is prayed that this court may be pleased to issue a writ of certiorari. Any other written order or direction on 15/9/2016 and that is annexure Q and 18/10/2016 annexure R. Now 2016 is an order by the land tribunal rejecting his application for implementation. And the second order is holding that Bailappa has in fact withdrawn. He has signed the order sheet. He was present. He has filed an affidavit. Therefore, the withdrawal is denied. In other words, he has not challenged the order of the tribunal passed in my favor on 26/7/2012. The order which has been sustained and made by the tribunal on 26/7/2012, conferring occupancy rights in my favor. It is not under challenge. All the subsequent proceedings before this court have upheld that order subject to one rider, namely, Bailappa has withdrawn or not. If Bailappa has withdrawn, that is the end of the matter. If Bailappa has not withdrawn, then you will have to consider it. That is our lead. So, nothing was left. Be that as it may, the petitioner hearing was himself a writ petitioner. And he had prepared a writ petition way back in the year 2012. Kindly come to page
108. Chandramodeshwara Shivacharya. The prayers are extracted in page 109. Issue a writ in the nature of certiorari or any other appropriate petition, etc. Including 26/7/2012. That is the order in my favor. So far as that is concerned, kindly come to para 2. This is what is said. As far as prayer number 1 and 2 are concerned, the impugned order passed by the land tribunal is already quashed by order dated 24/9 in WP number with the direction to the remanded matter expedition. Nothing survives for consideration of the said prayers. That is the order made. That is how that petition came to disposed of. Now, thereafterwards, I have taken the matter in appeal, and the order was modified. Now, that is not challenged by me. So, the writ appeal order confirming the occupancy rights in my favor, subject to the condition that Vailappa has withdrawn this thing, that has become final. And there was another prayer number 3. Interestingly, the
Glittering.
issue Mandamus.
Page Yenilla, page 110, Roman 3 prayer note.
Issue a writ of Mandamus to the respondents 1 to 3 to change the nameplates of Srikanteshwara Swami, etc., which is glittering in the gate of Lord Manjandeshwara, and put the nameplates of Manjandeshwara. Direct the third respondent for chant Manjandeshwara's name at the time of worshipping and to leave the enchanting. So this was the third prayer. Now, this prayer is much better than the prayer that went up to the Privy Council as to whether it should be Udagalai Nama or Tengalai Nama, not on the god, but on the elephant of the temple. So, anyway, no such. So far as prayer number 3 for a direction to change the nameplates, etc., is concerned, why is it to observe? They are not within the reach of the proceedings under 226. Then the petitioner there, that is the petitioner here, he pressed para 4. The learned counsel for the petitioner requested liberty be reserved to the petitioner to file an impleading application in the remanded proceeding, pending consideration before the land tribunal. Now that was opposed by me at para 5. Now kindly come to para 6, the finding of it. The question of granting or not granting leave to the petitioner to make an application not arise in this petition in the absence of any prayer for the same. If the petitioner ever makes an impleading application, kindly mark the next phrase. It is always open to the respondents to resist this. So, liberty was not given to him, but liberty was given to me to oppose the application. Open to the respondents to resist the same, taking such objections as are tenable in law. No opinion whatsoever is required to be expressed on the petitioner's oral prayer. All applications shall be considered by the tribunal strictly in accordance with the land. That is how this thing came to be disposed of. So there ends the story of his challenge to the 26/7/2012 order. That has become final. There is no further challenge. Then subsequently, as the South Court has already repeated, Vailappa's application was withdrawal of the application was confirmed
But by then, Bailappa was dead. So, writ petitions were filed, and the petitioner herein is also a writ petitioner. That is how that order is found at page 149. I've already brought it to the notice of the court that the order was set aside and remanded again to that limited extent, namely to consider Bailappa's trial application. Well, therefore, this retribution to that extent, he succeeded in getting the order set aside because it was against a dead person. He was sailing with the other petitioners and the petitions, all the petitions were allowed. But what is interesting to note is para 16 mechanism 165. Here he had made an application IA number 1, 2014, for substituting him name the Matadipati. This was considered at para 16. Before pointing in this case, IA number 1 of 14 in WP number so on for substituting the name of Matadipati is also to be considered. Whether Ramalingeshwara Math is in existence, if it is in existence, who is in charge of the administration or management, whether the said Math has any legally recognizable interest in the land, etc., require factual determination. They cannot be resolved in the proceedings under Article 226 of the Constitution. My very respectful submission is, all force this declaration applies to the present case. Because he has not established his time. He was never a party to the proceedings. At no point of time earlier to the grant of occupancy rights in my favor can he challenge the proceedings of this whatever, whatsoever ground. Therefore, the very declaration that they cannot be resolved in the proceedings and Article 226 of the Constitution. The ends of justice would be met by directing the people to pass appropriate orders of the application for implement, which is said to be pending. That order is now. Next page, last sentence. Ramalingeshwara Math may exercise the liberty of seeking the review of the said order, mainly market. Which order? The order of the writ appellate, where the grant of occupancy rights in my favor is confirmed, subject to this. So that is writ appeal 6946 and 55 of 2012. So Ramalingeshwara Math may exercise the liberty seeking the review of the said order or of challenging it by way of appeal if it has liberty. These observations, IA number 1 of 14 in WP number is discussed. No such review is right. No such.
No review. There was no review.
So this was a limited opening given to them. That they may seek a review of the writ appeal.
Yes.
So, my very respectful submission is on all courts, these proceedings conclude the controversy between this petitioner and the respondents who are conferred occupancy rights by order dated 26. And it is also of interest to note that as early as in 1970, the petitioner had prepared a suit. He has suppressed all these facts. Therefore, kindly permit me to produce. Comprehensively, all the documents which they mentioned.
So I think the courts leave to make use of that paper.
Only produced. Being filed in your mat. But this is being produced in that order. 1-4.
Petitioner has suppressed all the facts.
Compilation is fine. Things taken on the. Yes.
Kindly permit me to show. When you come to page 100, this was a suit filed by the petitioner hearing. Seeking a declaration of his title and restoration of the land. Issues are framed at paragraph 5, page 206. Is that possession of the government? Kindly come to page 206. Issues are framed. And corrected. He did not seek a declaration, but the possession issue was gone into. In this suit for possession, he wanted the government to hand over the possession of the property. The same assertion as he has done it in the present petition. Kindly, the following issues have been framed. Whether the plaintiff was titled to the suit scheduled property. This property was admittedly part of it. He had claimed over 220 acres, which all the survey numbers from 60 to 74. So this particular survey number was also item number 17. So the first issue was whether plaintiff was titled to the suit scheduled property. Now this was negative. Next page, the findings are given. At 207. My findings are plaintiff has not proved that he has the title to the scheduled property. Second phrase, whether the plaintiff is entitled to possession of this property. The finding on that issue is plaintiff is not entitled to possession of this property. Then issue number 5 may continue. Whether the suit is bad for non-joinder of parties. The suit is bad for non-joinder of parties in the finding. So this was the order made. Very interestingly, it has been made. This decree was given immediately after the Land Reforms Act came into force on 1370. Just over a month, there are 7 April. So his case was summarily sealed. I don't think they have preferred an appeal against this particular. So this is one aspect which he has suppressed. Secondly,
He had also suffered a decree at the hands of an educational trust. Which decree the court will get it at page 234. Of course, he files a memo in that suit. 234 memo. So this was a suit filed by Ramalingeshwara Educational Charitable Trust. So whatever this is the. So this was with reference to his own title to the post. At the intervention of Sri Jagadguru Panchapita of Kashi, Akapuri, Sri Chandrasekhara Shivacharya Swamigalu Great and other Matadipati, the senior devotees of the mat. The parties of the above have arrived at settlement in the interest of the mat and to safeguard the mat property. Thereby, the defendant is willing to give up his post of Matadipati of Sri Ramalingeshwara Bhatt wherefore the defendant prays that he has no objection to pass a judgment and decree in favor of the plaintiffs as prayed for. So this memo was accepted and a decree has been passed at the next page. The typed copy is at page 238. This decree was made on 28/7/1992. When we come to page 239, 25/7/1992. For a declaration that the purported injunction of the defendant Matadipati Ramalingeshwara Bhatt and its main branch Sri Gurulinga Vadiyar Bhatt Vadapet dated is null and void for permanent injunction and consequent declaration. So what is the decree? Last paragraph. This suit coming in for final disposal before so and so in the presence of swords for the plaintiffs and NVS advocates for the defendant. It is ordered and decreed that A, that the purported installation of the defendant as Matadipati of Sri Ramalingeshwara Bhatt and its main branch Gurulinga Raja Vadiyar Bhatt Vadapet dated 14/10/88 null and void. So that is the declaration. The defendant and his power of attorney is permanently restrained from alienating the property. Shiva Yogeshwara Shivacharya, Sarvadhikari and Matadipati of application and its main branch itself. As per the of Pradipita, and it is further ordered and decreed that the defendant to pay the costs. That is. So this also has become final that there is no further litigation. So all these facts the petitioner ought to have placed before the which go to the root of the claim he has made of having any subsisting interest. Be that as it may, as the Son Court has noticed, at no point of time he either went to the tribunal claiming ownership of the property, much less did he come before the Son of Court claiming ownership and consequently challenging. He preferred one more writ petition, which came up for consideration for the sum that I have already brought it.
So, for suppression of these facts, his repetition is liable. He cannot come with claims apart from delay and latches and restitution. For suppression of these facts, because these facts go to the root of the matter, of the root of his claim, claiming ownership of it. And it is also recorded by the land tribunal that the petitioner here was hand in glove with the rival claimant, and therefore they were freely selling the part and parcel of these lands to third parties to create third party interest. So that is the binding record. So these submissions are very extensive. Restriction is not. For the submissions I am making, who is going to deal with them in a more exhaustive manner. Therefore, I have quite repetition. I have dreadful. Station 143 2000. Expectation. It's filed by the subsequent purchaser.
To appear for?
I appear for Lord's respondents number 4 to 13 for the LRs of Lord's the grantees.
Lords of?
Grantees. That is Chamma alias Padmavatam and Venkatraman.
You are the other grantee, isn't it?
Please.
One is the Bailappa's grant.
One is Milords. Bailappa Milords was the rival claimant.
Correct.
Ramakrishnappa Milords was the brother of Bailappa.
Correct. So that's one claim.
That is one claim.
You are the.
I am Milords for the other claim.
Other.
4 times Milords the occupancy rates have been granted in favor of Milords. These LRs of Milords, the original grantees. That is Uchamma and
Correct. But inter se, your claim and claim of the has been settled, isn't it? Or independent claims?
These independent claims, Milords, is there is no dispute. Milords, totally 34 acres, 33 Milords is the totally Milords 34 acres, 32 in survey number 72. What has been granted Milords is 70 acres, 16 each.
That is Uchamma and Venkatramaya 17 acres.
17 acres each. 17 acres, 16.
Yes.
within themselves plots, there is no dispute. Always plots, they got plots together in all the proceedings. Plots in the present repetition, that is plots of 1433. Plots, these plots a subsequent purchaser of plots 1 acre 20 hectares. He had to have purchased plots by the mud. By respectful submission plots in the petition itself plots is not maintainable. And plots, the subsequent purchasers plots have no locus to challenge plots the order of the land title. So in that regard, plots, I am relying upon one decision, the Honorable Court. So I have covered plots different positions, but plots the first decision to give plots is at page number 98. The division bench of this honorable court plots considering the locus of the subsequent purchase. That is plots in 2010 SEC online Karnataka 5262. But para 9 and 10 plots has categorically held that the subsequent purchasers have no locus to maintain the petition. Page 102, para 9. Interplead filed by the appellant is also liable to be dismissed on the other ground, but reason that the appellant purchased the land in question on 30/8/1980, which is not in dispute. It is also not in dispute that the deceased Mandagi Saab has filed his form number 7 for registration of occupancy rates dated 14/11/1975, and the first time occupancy rates has been registered in the name of the deceased Mandagi Saab on 5/9/1980, and thereafter on 31/12/1981, and also in the year 1983. The said matter has come up before the land tribunal. Therefore, being a subsequent purchaser, he cannot have any right to question the tenancy rights, registration of occupancy rates, best in favor of R2A and R2B. The land tribunal, after critical evaluation of oral and documentary evidence, has registered the occupancy rates strictly in consonance with the relevant provisions of the Karnataka Land Reforms Act and appellant, knowing fully well that the matter has been pending before the land has chosen to purchase the land. Hence, the erstwhile owner has got no title of the tenanted land to sell the same in favor of the appellant, which has been vested with the government as on 1/3/1970. Therefore, the alleged purchase made by the appellant for the land in question is null and void in the area. This preliminary objection notes is also applicable to notes in another case where notes one educational trust notes has also come before the Son by filing another expedition.
Which M.R. Rajgopal appeared.
Please. The compilation notes I have narrated the facts. The compilation of notes documents. Spiral waiting.
Yes.
The lands were tenanted lands, notes in year 1936 itself. However, notes the RTCs continued notes from 1966-67 onwards. Then notes 31/12/1974 is the application made in form number 7. Notes the first order of the land tribunal notes on 19/7/1977. That is at page number 21. Then notes a petition came to be filed notes by the rival claimant. That is in petition 10135 of 1977. Notes which came to be allowed on 8/12/1980. Stating that notes when the rival application is pending consideration, it has to be considered together. Notes accordingly, the matter was remanded back to the land tribunal. Notes on 24/5/1988. The land tribunal notes passes an order notes in favor of notes Vailappa. That is the second order. Then notes that order of the land tribunal came to be questioned notes by the grantees hearing. That is in petition 29259 of 1991. Notes which came to be allowed.
So who is Bailappa vis-a-vis?
Notes Vailappa notes is he claims notes that he was also notes cultivating the land, the same land, and he had also made an application. So that application was not considered notes initiated. Then thereafter, notes this on report notes demands the matter back the land tribunal to consider both the application and thereafter to decide. Then notes the second order, that is on 24/5/1988 is passed, granting notes the occupancy rights in favor of Vailappa. Then notes that came to be questioned by the Kuchama and Venkatramaya. Then notes on 5/12/2006, that is at page number 69. The writ petition was allowed and the matter was remitted back. Then notes Vailappa files writ appeal 943 of 2007. Then notes even the writ appeal was dismissed. Once again, notes confirming the order passed by the learned signature, remitting the matter back to the land tribunal. Notes one important aspect of notes is that this Ramakrishnappa notes files an application in the writ appeal to come on record. Notes that is at page number 73. Page number 73. That is writ appeal 943 of 2007. Notes in which at page number 74 there is a reference to the application made by Ramakrishna. Notes that is miscellaneous writ number at the bottom. Miscellaneous writ number 5878 of 2010 is filed under section 115 of CPC trying to include the including applicant H. Ramakrishnappa as one of the co-appellant in the above writ appeal for the reasons stated. This application notes has not been allowed. That is at page number 80. Last note sentence. in view of the dismissal of the writ appeal, consideration of miscellaneous writ numbers or impleading do not arise for consideration. That's my submission, Lords, is that a statement was made that he came to know about the proceedings in the year 2012 and he makes an application. When Lord's application for withdrawal of form number 7 is filed by Lord's Bailappa. It is not so, Lords. In 2010 itself, he was fully aware of the proceedings. And he makes an application to come on record. That was not favorably considered.
Just one. Yes. So he was aware of it.
He was aware of Lord's proceedings. Then after that, Lords, these are the dates, Lords, Learned Senior Counsel, Lords, has addressed the arguments regard to the withdrawal of form number 7 application filed and Lords remitted back to the tribunal only to consider those that particular limited point.
So Ramakrishna was aware much earlier to August of 2010.
Then,
Yes.
subsequently, after the remand, that is the next page, 26/7/2012 notes is the occupancy rates granted. That is page number 81, which is the third order. The writ petition was not filed by Bailappa, once again stating that he has not made any such application for withdrawal of form number 7. But the writ petition was allowed and the matter was remitted back only to consider that particular limited point. Then the appeal was filed. Even in the appeal also writ appeal. The only limited point that was asked to be considered by the land tribunal is only with regard to whether such an application is made or not. But that was considered once again by the land tribunal. But on 27/5/2014, the land tribunal passes an order, that is the fourth order, granting once again occupancy rights in our favor, holding categorically that no such the application was made by him and it was recorded in the order sheet. And accordingly, it is only the application which was filed by Uchamma and Venkatramaya are to be considered. And accordingly, the occupancy rights were granted. Then, it came back to once again in dishonorable court on the ground that the legal heirs were not brought on record by the time H. Bailappa had expired. Then it is only once again, even the second remand also there is a categorical observation that only that limited point will be considered. But now, the present petitioner who is raising his title is under the execution of a sale deed by the Mandamus. That is to the extent of 1 acre 20 guitas out of this 34 acres 30. My respectful submission is that the mud plots was not a party in all the proceedings, and the property plots did not belong to them. That has been plots settled, plots in several proceedings, including the decree, stating that they do not have any title. In other words, plots, the document is a void document. A person plots who doesn't have any marketable title or ownership of the property, but if he executes, by that plots, no inference can be drawn that he had the marketable title and the purchaser, who is the petitioner here, has any interest in the property. It's a void document. With regard to that, the relevant notes.
The injunction order that was referred to earlier, stating that he cannot execute sale deeds. In the previous, so whether GPA holders who have now executed have been injuncted by.
Totally, not the mud itself was not or any other person claiming through the mud. Not were restrained from lots dealing with this property. That is what lots the decree is. But even before that, not that comes into existence on a later date. Even before that, lots kindly come to lots page 200. 200, which is the first decree lots, which is suffered by the mud lots, the certified copy notes starts at page number 155. The typed copy notes is at page number 200. Learned Senior Counsel notes has referred to the issues and the findings. Now, notes, with the leave of notes, by notes, I would like to notes refer to few of the findings notes, which has bearing on the issue. In fact, notes, Learned Senior Counsel for the petition of notes has also referred to Revenue Commissioner's orders and several documents notes by which it is stated that it belongs to Ramalingeshwar Mart and they should be handed over the title and the Kata and other things. All those things have been read. Those documents notes have been looked into and taken into consideration by the trial court, and a categorical finding is given. That is at page number 207. As seen from the averments made, page 207. As seen from the averments made by the plaintiff, these scheduled properties are said to have been given by Karadir rulers. Are said to have been given by the Karadir rulers the Guru of Ramalingeshwar Mutt. Plaintiff has not established that there was a mutt known as Ramalingeshwar Mutt and Karadir rulers settled the properties mentioned in the schedule to the Guru of Ramalingeshwar Mutt. Further, must prove that the Karadir rulers had sovereignty over the area where the scheduled properties are situated. Further, the plaintiff must also prove that he is the Sarvadhikari of Ramalingeshwar, being the son of Nanjundara, who is said to be the previous Sarvadhikari. The plaintiff has not proved any one of these issues, these facts. The plaintiff, apart from deposing to certain documents which is in the custody of the second defendant, has not placed any independent materials to support that there existed a Ramalingeshwar Mutt that Karadir rulers endowed the scheduled properties to the Guru of the Mutt and that he is the Sarvadhikari of the Mutt, being the son of Nanjundara. Exhibit P1 is a file pertaining to the Mysore Revenue Survey Department. The file number 137 is for the period between 1880 and 1907. It is the case of the plaintiff that one Gangadharaya, father of Nanjundara, was the manager of the plaintiff, and he made an application to the Revenue Commissioner for change of Kata in respect of the scheduled property in favor of the plaintiff. Exhibit P1 copy of the settlement is clear how a copy is retained in the file and not the original. In the absence of the original petition, the cannot be said that the Gangadharaya gave an application for the change of khata as per the original Exhibit P1A. This application is dated 1/2/1880 and it is typed application. Exhibit P1B is said to be an endorsement issued by the Office of the Superintendent of Survey and Land Records in Bangalore to Gangadharaya, stating that the entire records have been submitted to the Revenue Commissioner. Exhibit P1C is said to be another endorsement addressed to Gangadharaya by the Office of the Revenue Commissioner, stating that the matter is decided in his favor. It bears the signature of one Chelavayengar. It is in the evidence of DW10 Ramarao, who is the Assistant Director of Land Records, that there was no revenue commissioner in the state of Mysore by name Chelavayengar during the year 1988. This endorsement appears to be not genuine. Exhibit P1D is said to be another endorsement issued to one Vishwanath for crediting rupees 4.8, and this endorsement bears the signature of Chelavayengar. By the side of signature, the letter ST is mentioned. This fact clearly shows that it is not the original endorsement. The evidence of PW1 is that Revenue Commissioner prepared a list of branch funds of Ramalingeshwara in Mysore State as per Exhibit P1E. This exhibit is also signed by one Chelavayengar as Revenue Commissioner. The evidence of PW10 is clear enough to quote that there was no person by name Chelavayengar in the year 1880. The plaintiff avers that a joint committee inspected the plaintiff's fund and its properties and submitted a report as per Exhibit P1EA. It is seen from Exhibit P1EA that Ivan Anand Rao, Chelavayengar, Revenue Commissioner, and JP Grant, Survey Superintendent, inspected this spot and made a list of funds. This exhibit is unsigned. Therefore, no reliance can be placed on this exhibit. Exhibit P1EA is said to be the copy of the sanad granted by Rajaraja Naika. It is mentioned therein that this sanad was issued on 10/12/1492. This sanad is in English. The plaintiff wants the court to believe that the English language was prevailing in this country even in the year 1492. This exhibit bears the signature of one Chelavayengar. All these circumstances clearly go to show that these documents are got-up documents and they have been inserted in the file belonging to the second defendant. The learned counsel for the defendants stated that a departmental inquiry has been ordered for the insertion of these papers in the file. The one circumstance that Rajaraja Naika issued the sanad in favor of Ramalingeshwara in the English language is sufficient to hold that this document is a spurious document, and persons who are interested in knocking off the properties must have created these documents. So is a copy of the list of bank funds at bank and other places. No reliance can be placed on this list, and it is strange to note that even on this copy there is a signature of Chelavayengar. It seems that the alleged Revenue Commissioner Chelavayengar had no better business than signing on the alleged copies of the document. The exhibit P1ED is said to be an endorsement issued by Chelavayengar as the Revenue Commissioner ordering the properties gifted by Shivappa Naika of Keladi on 7/5/1967 to be handed over to the Sarvadhikari of the Ramalingeshwara Fund. This endorsement bears the signature of one Chelavayengar, and behind this signature, the letters signed are mentioned. Chelavayengar was not the Revenue Commissioner of the Pharmacy of the This document cannot be relied upon to quote that first defendant ordered delivery of the suit schedule property to the Sarvadhikari of the plaintiff fund during the year 18. Exhibit P1A is typewritten matters stating that Ganapati temple is situated in Lavatory Road, Cross some dimensions, and it is supposed to have been signed by Madurai Shetty and Narayan. Below this, there is the signature of Chelavayengar. This endorsement was issued already by the Revenue Commissioner. It is not clear how the Chelavayengar as the Revenue Commissioner signed this duplicate. Exhibit P1EG is said to be a list of properties of the plaintiff fund at Karnataka. This list is signed by Patel Rudrappa. This is the copy of the list supposed to have been prepared by Patel. It is not clear that what made the alleged Revenue Commissioner Chelavayengar sign this copy of is said to be a copy of the joint inspection of the Commissioner of Bangalore, along with the survey superintendent on 10/8/1880. This is a copy of the report, and no one has certified that this is a copy, and some pages are attached to this exhibit, and they bear the signature of one Chalawayengar. I fail to understand how Chalawayengar, the Revenue Commissioner, can sign the report prepared by Deputy Commissioner and the Survey Superintendent. Behind the signature of Chalawayengar, the letters SD are not say any specifically not say indicated that SD is always plots that it is for the copy signed. It doesn't bear the signature, but plots next to lots SD always there is a signature bound lots of Chalawayengar. The observation made by the court. All these facts clearly goes to that these documents are not denied documents. Exhibit P1E1 is said to be an uncertified copy of the tenure of it is said to have been signed by C. Rangaja, the then Revenue Commissioner, and but the court plots considers other aspects here. Plots ultimately the prior court holds plots that these are the documents which are created, concocted, and spurious documents. And it holds plots that based on this cannot be said that the what is the owner of the property. Another observation notes the judgment and decree is at page number 222. Page number 222. Therefore, the evidence of PW1 that he resided at Aranhalli and was managing the properties of the fund cannot be claimed. In cross-examination, he admitted that his alleged grandfather gave possession of all his good properties to the government, and that being the case, there was no necessity for PW1 to remain at Aranhalli. The evidence adduced by the parties in this case is conclusively proved that plaintiff's claim, the bogus claim, mark of this situation. The plaintiff has not made out the case that there is a ramification or that he is the Sarvadhikari of that part. The defendants contended that they are not in possession of this property. It is strange to note that the plaintiff did not produce the extracts of index of lands or record of rights along with the plaintiff. Even after the defendants produced these extracts, the plaintiff has not cared to implead the persons who are in possession of the properties as parties. But this categorical observation notes, related to one of the contentions that they argue that N.K. Surappa was only the power of attorney or not, he was holding the property on behalf of the man. But if that is the case, not at least when they seek the possession of the property, he should have been arrayed as a party. Right, seeing notes in the cast type. Most private parties notes have been impleaded. The direction notes is only or the suit is only filed against the authorities of the state government. That is at page number 200. 200. In the cast title. The defendants are Lord's State of Mysore, Commissioner of Survey Settlement, Divisional Commissioner, Deputy Commissioner Shumaga, Commissioner Corporation of City of Bangalore, Chairman City Improvement Trust Board Bangalore, the land acquisition of attached. No other private parties notes have been arrayed and impleaded.
Whether these have attained finality?
Not this judgment Lord's decree has attained finality.
How do you get over this? The suit findings, how do you get over the suit findings? Yes.
After this, brought the suit. Brought Ramalingeshwara Education Charitable Trust has filed another suit in which brought the memo was filed by the Peetadipati stating that he is willing to concede for the decretal of the school, and lots by which he has been restrained from lots alienating any of the properties. That has been pointed out by the learned speaker. Now, lots the government passed an order. Lots that is on 28/12/1996. Declared Lords Shiva Yogi Shivacharya as the Matadipati of the Ramalingeshwar Mutt. Lords, that is Lords, page 243. Lords, in which there is a reference to Lords, this 28/12/1996 order. In the first paragraph, Lords, third line. Pursuant to Lords, the proceedings. Shiva Yogeshwara Shivacharyarannu ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 28/12/96 ಆದೇಶ ಮೂಲ ದಾವೆ ಸಂಖ್ಯೆ 84 ಆಫ್ 1970. That is this particular Lord's judgment and decree. Taking note of this judgment and decree, Lords, this 2004 order, Lords, came to be passed. Withdrawing that declaration, Shiva Yogi Shivacharya Lords was declared as Matadipati of Ramalingeshwar Mutt in the year 1986. Subsequently, Lords, government taking note of this judgment and decree, Lords, it withdraws its earlier order by virtue of this 22/12/2004 order. Says Lords, the government order 22/12/2004 ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಶ್ರೀ ಶಿವಯೋಗೇಶ್ವರ ಶಿವಾಚಾರ್ಯರು ಶ್ರೀ ರಾಮಲಿಂಗೇಶ್ವರ ಮಠದ ಮಠಾಧಿಪತಿಗಳನ್ನು ಘೋಷಿಸಿದ್ದ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 28/12/96 ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟರ್ಜಿ ಸಂಖ್ಯೆ 9/27 ಆದೇಶದನ್ವಯ ಹಿಂತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಚಂದ್ರಮೌಳೇಶ್ವರ ಶಿವಾಚಾರ್ಯ ಸ್ವಾಮೀಜಿಯವರನ್ನು ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲೆಯ ತಾಲೂಕಿನ ಹಾರನಹಳ್ಳಿ ರಾಮಲಿಂಗೇಶ್ವರ ಮಠದ ಮಠಾಧಿಪತಿಗಳನ್ನು ಘೋಷಿಸಲಾಗಿದೆ. The government passes two orders. One is withdrawing the earlier order and declaring another Lords Chandramoleshwara Swamiji as Madadipati of Ramalingeshwar Mutt. But even this also Lords was the subject matter of the proceedings before this honorable court. That is at page number 257. That is in petition 9307 of 2005. Yes. That's 257.
Four order was challenged.
Yes.
What happened?
Once the honorable court observes Lords that government cannot declare or issue such declaration, and it has to be declared by only by the competent civil. And further observes Lord that both of these orders, that is, one is 1996 order, it doesn't get revived because of washing of the subsequent order. But that is the observation made. And ultimately, Lords, it holds that no one is the Madhadipati of the Mutt, and it is only the civil court which can declare. Lords, kindly see the observations, Lord, that is at para number 10, page number 271. Para 9 also. Para 9.
And here till 4:30,
Please.
some meeting I have had.
Previously.
Para 9.
Para 9. By the impugned order dated 22/12/2004, the earlier order appointing the petitioner in writ petition 9307 of 2005 and 41913 of 2008 and 2003 as the Matadipati and appointing the contesting respondent Chandramoreshwar as the Matadipati is withdrawn. There is no provision of law which empowers the government either to appoint or to remove Matadipati. Therefore, the said orders are liable to be quashed and they are accordingly quashed. Both. Then para 10. However, in the proceedings under Article 226 of the Constitution, this court is not required to determine as to who is the Matadipati, what is the mode of appointing the Matadipati, and or what are the customs, usages, and practices of a community in the matter of appointing the Matadipati. And 3. For whose benefit the Mata is established. It is made clear that the quashing of the impugned orders does not automatically revive the order dated 28/1/1996. That is the earlier order. Because what was under challenge initially was only 2004 order. But ultimately, as a matter of caution, this honorable court observes that it doesn't get revived. It is made clear that impugned order dated 22/12/2004 is quashed without creating any right in favor of any of the rival claimants. If any of the rival claimants want to hesitate their claim to be the Matadipati, they have to do so by approaching the competency bill, by filing a duly constitutional.
Yeah, according to you, they are placed worse off. In effect.
In effect, Lords, virtually, Lords, no Matadipati or Lords, anybody who Lords steps into the shoes of or claiming Lords that he is Matadipati has no existence at all by virtue of Lords the order of this honor. This order, Lords, has also attained penalty.
Declaration before the civil.
Yes.
That is in effect.
Yes. And this order, Lords, has also attained penalty.
1996 order, 2004 order, both go.
Please. My respectful submission, Lords, is that notwithstanding, Lords, this order, even otherwise also, Lords, by virtue of the declaration made by this in the year 1970s, Lords, that itself, Lords, is a point that no one gets any right or title, Lords, because the Mata has already approached this on the trial and suffered Lords decree at the hands of the trial. That judgment and decree attained penalty. And possession, Lords, continued with Lords whoever holding the possession of the property. That cannot be, Lords, reopened. In the case of Lords exercising the judicial review, Lords, insofar as the land tribunal's order is concerned. The land tribunal's order, Lords, is only with regard to the application made in form number 7, whether this person was cultivating the land or the other person. That is the only limited Lords issue. That issue, Lords, could be considered. But so far as, Lords, whether who is the owner of the property, Lords, so far as the petitioners are concerned, Lords, the judgment and decree of the civil court seizes, Lords, their claim. And as well as, Lords, this the order of this honorable court in writ petition 9307 rendered on 2nd of March 2009. Meanwhile, Lords, what happens is that they take advantage of, Lords, the alleged orders of revenue commissioner and others, Lords. They approach the authorities for entering their name in the revenue records. Notes at page number 48. The Madam Notes makes an application to the Tashildar. That is notes dated 35/2006. Notes it is in Kannada numbers. That is 35/2006. Notes where in the subject Vishaya, Bengaluru Uttara Appara Taluku Yellanka Hukki Jargabande Kaval Kamada survey number 60ರಿಂದ 76ರವರೆಗಿನ ಸರ್ವೆ ನಂಬರ್ 74 ಹೊರತುಪಡಿಸಿ 220 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಿಗೆ ಖಾತಾ ಬದಲಾವಣೆ ಕೋರಿ ಶ್ರೀ ಚಂದ್ರಮೌಳೇಶ್ವರ ಶಿವಾಚಾರ್ಯ ಸ್ವಾಮಿ ಮಠಾಧಿಪತಿ ರಾಮಲಿಂಗೇಶ್ವರ ಮಠ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದೆ. This is plots after all these plots the proceedings. 2 suits which was declared where plots this Chandramauleshwara Swami himself files a memo. And based on these plots, the revenue entries were made by virtue of plot the order at page number 252 by the Tashildar after taking plots the approval of the assistant commissioner. Plots I will take my lots to the relevant portion plots at page number 255.
The government will have to comment on this.
Page 55. Not the last paragraph. ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ರಾಮಚಂದ್ರಪ್ಪ ಅವರ ವರದಿ ಹಾಗೂ ತಾಲೂಕು ತಯಾರಿಸಿರುವ ನಕ್ಷೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಉತ್ತರ ಅವರ ತಾಲೂಕು ಜಾರಕೊಂಡೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 64/1ರಲ್ಲಿ 5 ಎಕರೆ 64/3ರಲ್ಲಿ 5 ಎಕರೆ 27 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 72ರಲ್ಲಿ 34 ಎಕರೆ 2 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 77/2ರಲ್ಲಿ 38 ಗುಂಟೆ ಕೊಟ್ಟು 42.12 ಗುಂಟೆ, 62 ಎಕರೆ 12 ಗುಂಟೆ ಖರಾಬ್ ಜಾತ 35.27 ಗುಂಟೆ ಜಮೀನನ್ನು ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಹಾಗೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಅಂತಿಮ ಆದೇಶದ ತೀರ್ಮಾನದ ಷರತ್ತಿಗೆ ಒಳಪಡಿಸಿ ಶ್ರೀ ಚಂದ್ರಮೌಳೇಶ್ವರ ಶಿವಾಚಾರ್ಯ ಸ್ವಾಮಿ ಮಠಾಧಿಪತಿ ರಾಮಲಿಂಗೇಶ್ವರ ಮಠ ಇವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಆದೇಶಿಸಿ. There are 2 important aspects which emerges from this order. One is that the Madhadipati Lords has suppressed the material facts and concealed Lords with regard to the earlier Lords judgment and decree which is suffered at the hands of Lords the trial. And Lords, the order Lords which has been passed subsequently by this order. Otherwise, my lords, there was no occasion for the authorities to pass this order, making it subject to the orders of the court or the land tribunal. Even otherwise, my lords, this making of revenue entries has been made subject to my lords outcome of the land tribunal's orders. The land tribunal, my lords, has now passed an order. Year 2016, that is 18/10/2016, in favor of Lords the granting sale.
But all this is outside the scope of litigation.
Yes.
Finally, what they are claiming only through occupancy rights, isn't it?
Yes.
And by virtue of sale deed, etc. So now finally it boils down to occupancy rights. That's all we have to determine.
Yes.
And the writ appeal, in effect, has affirmed the finding of occupancy rights subject to inquiry as to whether he has withdrawn or not. So the finding whether it's withdrawn or not, I'm saying this is your argument. The finding as to whether it's withdrawn or not has now been made.
Yes. Not one another aspect not is that. So far as not the case filed by Ramakrishna claims to be a rival claim. But so far as that issue is concerned, only not concerning the occupancy rights granted in favor of the grantees case. But so far as the other two petitions are concerned, which is now filed by Mud subsequent to purchases, they are concerned they don't have any locus standi at all to come before this one. If at all if they have any right, they have the right as against the person who has executed the sale. And these documents would clearly demonstrate that the person who executed the sale had no means of semblance of right or title over the property in view of all these. But now they are coming before this honor in the proceedings where the land tribunal's order is under judicial review by enlarging the scope of the consideration, that is of the judicial review, which is totally impermissible. If at all they have any right, it is a case once again to approach the civil court in a constituted civil suit and seek appropriate relief as against the persons who have executed the same. But here is a case where whether they come before this honorable court to argue whether the occupancy rights granted in favor of the grantees hearing or should it have been granted in favor of Ramakrishna. So that is virtually is impermissible. These aspects do not fall within the judicial review so far as considering the scope of the order passed by the land. But in view of these submissions, I am relying upon the decisions of.
So you are saying that their vendors' rights, through whom they eventually claim, is only a matter for inquiry in the present proceedings, and they'll be bound by whatever adjudication is to be done insofar as the rights of their eventual original vendors, which is the decision regarding occupancy.
But one more submission is that so far as their title, their interest over the property in question, need not be gone in view of there is already a declaration made by DCB. Those findings have attained finality. It is not disturbed, it is intact.
More chance has been given that you forgot. Your own argument relating to the writ petition, court has given them one more chance to go to the civil court.
That they did not make use of it. In view of the finding, whether is it open to this honorable court to give a different finding to hold that even they have some semblance of right, is my submission. But I argue not such the decisions are concerned. Moreover.
Monday we will continue on Monday. One more parted matter. I couldn't take that up today. Have that tomorrow. So this will continue on Monday. Then after you finish,
that's it.
Then a reply from that. Lord Council.
Same copies notes are placed along with the statement of objections notes expressed.
Let us see, the requirement for. I don't know. Let us. Government, you have the land tribunal records are there. You have it. Keep it. No, correct, but now, according to me, it's a legal question. It's no more a question of factual. It boils down, according to me, to legal questions after the writ appeals orders. Factual inquiry, how can we reopen factual matters? Let us see. Anyhow, it's there. That is there. Of objections filed by R4 to statement of objections filed by R4 to R38 in WPA 1433-2 of 2020 is filed and taken on record. You have served copies.
Sir.
Learn culture. Argue. But I want it to be concluded by next week. Because there'll be a change of roster. Then again, first of all, facts are little factually intensive. If there's a break, it will be difficult for me. But that will give you time. Once the oral arguments are done, everybody must file their written submissions.
Manoj, serial number 40.
Just 1 minute. Final hearing, no final hearing next week. Dates you can take from which week, etc. from the court office. The Mandamus matters in repeat and make a request. It will be listed. Nodi, the court officer gave small matters will be taken. Hearing matters, matra, I will not take.
My lord, serial number 44 connected.
No.
Sir, court officer.
Sir,
serial number 44, ನನ್ನ colleague ಅಲ್ಲಿ ಇದ್ದಾರೆ. Case number 354.
ಹೇಳಿ ಸರ್ 44 ಏನು ಸರ್ ಅದು?
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ ಸರ್, ಮೊನ್ನೆ ಕನೆಕ್ಟ್ ಆಯ್ತು ಆ ಕೇಸ್ ಅಲ್ಲಿ. ಇದಕ್ಕೆ
ನಂಬರ್ ಹೇಳಿ, ನಂಬರ್ ಕನೆಕ್ಟೆಡ್
3594 of 22 ಸರ್, WP
94 of 22. ಆಯ್ತು ಸರ್, ಹೇಳ್ತೀವಿ ಸರ್, ಹೇಳ್ತೀವಿ. ಆಯ್ತು ಸರ್, 3594 of 22.
ಎಸ್ ಸರ್.
ಓಕೆ ಸರ್, ಇದು ಮ್ಯಾಂಡಮಸ್ ಇದಲ್ವಾ ಸರ್? ಇದು ಮ್ಯಾಂಡಮಸ್ ಯಾವುದು? ಸೋಮಶೇಖರ್ ಕೇಳಿ. ಮ್ಯಾಂಡಮಸ್ ಅಂತಂದ್ರು. ಅದೇ ಆಗ್ತದೆ ಸರ್, ಅದನ್ನ ಆಗ್ತೀವಿ ಸರ್. ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿ ಸರ್. 52 ಮ್ಯಾಂಡಮಸ್ ನಿಮ್ದು 10th ಬರುತ್ತೆ ಸರ್, 10th ಬರುತ್ತೆ. 9th ರೀಚ್ ಆಗಲ್ಲ ಜಾಸ್ತಿ ಇದೆ. 3594 IAS ಬರಲ್ಲ ಯಾವುದು. 41 ನಾಳೆ ಬರುತ್ತೆ. ನಾಳೆ ಬರುತ್ತೆ. ಇಲ್ಲ ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ. ನಾಳೆ 10ನೇ ತಾರೀಕು ಬರುತ್ತೆ, ನಾಳೆ ಬರಲ್ಲ. 57 ಇಲ್ಲ. ಯಾವತ್ತು ಕೇಳ್ಕೊಂಡ ನೀವು ಯಾವತ್ತು ಕೇಳ್ತೀರ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಏನೇ ಡೇಟ್ ಕೊಡಿ ಸರ್.
ಆ ವಾರದಲ್ಲಿ ಹಾಕಿ ಅಂತಂದ್ರು 25th ಅಂತ ಹಾಕಿದ್ರಿ. ಆ ವಾರದಲ್ಲಿ ಯಾವತ್ತಲ್ಲ 42 ಮಂಡೇನೆ ಬರ್ತದೆ ಸರ್. 48 ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ. ಮ್ಯಾಂಡಮಸ್ ರೀಚ್ ಆಗಿದೆ ಗೊತ್ತು. ಮ್ಯಾಂಡಮಸ್ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿದ್ರು, ಒಂದು ಮಾತ್ರ ಹೇಳಿದ್ರು ಅಷ್ಟೇ ಹೊರತು. ಡೇಟ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ವಾರದಲ್ಲಿ ಅಂತ ಹಾಕ್ತೀವಿ. 3 ಬರುತ್ತೆ. ಯಾವ್ದಾದ್ರು ಈಗ 48 ಅಲ್ವಾ, 25ನೇ ತಾರೀಕು ಮೇಲೆ ಯಾವತ್ತಾದ್ರೂ ಹೇಳಿ. ನೀವು ಯಾವತ್ತು ಹೇಳಿ, 25 ಮೇಲೆ ಯಾವತ್ತಾದ್ರೂ ಹೇಳಿ. 25 ಬೇಕಾ 30 ಬೇಕಾ ಯಾವತ್ತು ಹೇಳಿ. ಯಾವತ್ತು ಹೇಳ್ತೀರ ಅವತ್ತು? ಈ ತಿಂಗಳಲ್ಲೇ ಸರ್ 25. ಏನಂದ್ರೆ ದಿನ ಬಂದು ಅಟೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಬಂದು ಪಾಠ 26 ನಿಮ್ಗೆ ಯಾವತ್ ಬೇಕು ಹೇಳಿ. 25 ಅವಾಗನೇ 3 ಡೇಸ್ ಒಂದಿನ ಬರುತ್ತೆ. ಈಗ ಯಾವತ್ ಬೇಕು ಹೇಳಿ ಸರ್. 9th ಬಂದ್ರು ರೀಚ್ ಆಗಲ್ಲ, 10th ಬಂದ್ರು.
ಸರ್ 44 ಏನೇ ಡೇಟ್ ಕೊಡಿ ಸರ್.
3 ದಿವಸ ಬರುತ್ತೆ. ನೀವು ಕೊಡಲ್ಲ ನನಗೆ, ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಕೊಡಲ್ಲ ಅಂದ್ರೆ 10ನೇ ತಾರೀಕಿಗೆ ಹೋಗಿ. ನಾಳೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ, ಬರಲ್ಲ ಸರ್. ಹೇಳ್ತಲ್ಲ 25ಕ್ಕೆ 26 27 ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ರೋಸ್ಟ್ ಚೇಂಜ್ ಆದ್ರೆ ನಾನು ಏನ್ ಮಾಡಿ ಸರ್. ರೋಸ್ಟ್ ಚೇಂಜ್ ಆದ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ತೀನಿ. 43 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. 25th ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ ಬೇಡ ಹೇಳಿದ್ರಲ್ವಾ ನೀವು, ಹೇಳಿದ್ರಲ್ಲ 25 ಅಥವಾ 30 ಯಾವ್ದಾದ್ರು ಏನೇ 25 26 ಯಾವತ್ತಾದ್ರೂ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಅವತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಬಂದ್ರು. ಸರಿ ಆಯ್ತು, ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ ಸರ್. ಸರಿ ಹೋಗಿ ಸರ್. ಸರಿ ಹೋಗಿ ಆಯ್ತು ಹೋಗಿ ಆಯ್ತು. 11 ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು ಅಟೆಂಡ್ಮೆಂಟ್ ಬ್ಯಾಚ್ ಎಲ್ಲ 25 ಸರ್ ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಡೇಟ್ ಕೊಡಿ ಸರ್.
ಡೇಟ್ ಅಲ್ಲಿ 25th ಸರ್. ಅದು 25th ಇಲ್ಲ ಸರ್, 25th ಸರ್. ಹಲೋ
ಓಕೆ ಸರ್. ಓಕೆ ಸರ್.
ಈಗ ಎಂಟ್ರಿ ಮಾಡೋದು ಅಷ್ಟೇ. ನಾಳೆಗೊಂದು ಡೇಟ್ ಇದೆ.
ಓಕೆ ಸರ್.
ನಾನು ಬರ್ಕೊಂತೀನಿ. ಅದೇ ಏನಂತಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡೋದಿದೆ, ಅದು ಟೈಪ್ ಮಾಡಿ ಕಳಿಸ್ಕೊಡ್ತೀನಿ. ಇವಾಗ ಹೇಳ